listing of a matter on 8 Lordship, 8 of May Lordship. This matter was last listed on 9/11 Lordship,
8th of
8 of May.
May I go, sir? A recognition and item for listing matter.
any listing matters, give it to him.
Okay.
If it is not for today,
My lord, prayer for listing of one unlisted motion matter, my lord. For
what is the urgency?
my lord, those schools, my lord, whose cancellations were affiliation was cancelled, my lord. Now the students are not being able to give the compartmental examination. Some of the students.
Naturally, you will not be able to. You will have to go to some other school. That affiliation is cancelled.
My lord, it may kindly be taken up.
Not today.
My lord, 4th is the last date, my lord.
Not today.
My lord, tomorrow then.
Tomorrow.
Highly obliged.
May it be please your lordship. Lordship, I beg to mention item number 22. In this case, lordship, we would like to file our affidavit in reply, lordship.
When was the affidavit filed? Second post LDA.
Yes, lordship.
What development can you make by filing an affidavit? On the prayer of the Miss, as you are not here,
No, lordship, not yet.
on the prayer made on behalf of the learned counsel for the petitioner, Ms. K. Devi, list those matters again on 6/5/2020, enabling the petitioner to file an affidavit in reply to the affidavit in opposition filed by the departmental authorities. No further adjournment shall be granted in the matter.
May it please your lordship. My lord, I beg to mention, my lord, regarding item number 9, an additional affidavit is filed to bring some additional document on record, my lord. My lord, this is not tagged, my lord. Kindly call for the record.
This was, we had closed the matter.
Oh, my lord.
Anyway, get it.
Highly obliged, your lordship.
May I please, my lord? My lord, I have filed in IA yesterday, my lord, for
On that
yes,
correction. Get it, 2 o'clock.
yes, sir. I have license.
May I lordship? Lordship, I beg to mention item number 24. Against counsel, Mr. R. Chaudhary is absent today due to illness. Matter may be adjourned.
What has happened to Mr. R. H. Chaudhary? He's not regularly attending court,
Favor today.
huh?
Favor. Call for favor.
Not keeping well.
No.
On the last 2 occasions also, he was not keeping well. He's not attending court.
I don't know, lordship.
No, if you don't know, why are you making a mention? My question is he suffering from serious ailment? Because last 2 dates in this case, he's not appearing. Just wanted to know what has happened to him.
Any date, lordship.
Tomorrow. That means he's well,
No, lordship. Unwell.
unwell. Last date also. What has happened to him? Some serious ailment, we will extend the time. We'll take it up after some time. Or if it is something,
No,
nothing,
lordship. Tomorrow.
tomorrow. On the prayer made on behalf of Mr. R. H. Chaudhary, list this matter again on 6/5/2024.
Oblige.
My lord, non-payment of retirement benefit and pension, my lord, principal for the college, my lord. It has not been listed after.
When did he retire?
My lord, in the year 2017 itself.
70. After TD. Nothing more to be added.
Well,
We have to pass the orders.
yes,
We will pass, if possible, we'll pass it today itself. If not, we'll fix a date. On that day, the order will be delivered.
obliged.
Same thing. ये दोनों में पहला वाला delivery order is deferred today and he listed on next one on We are disposing of the matter. We will pass our orders. Let's see if we can give him an opportunity. Mr. Ali, we'll start trying.
Thank you.
Dispose of it. We will permit you your case for provincialization consideration.
Right.
And between you two, you file appeal as to who would be the most appropriate person. Till that time, let the government decide who would be the appropriate person, file an appeal there.
Mal.
But we are allowing his case.
Till then, my service may not be discharged.
Huh?
Till then, our service may not.
We don't know. We'll leave it to the director.
March. Commissioner, just file it direct. Commissioner. As per the-
Let's see how it comes out.
March.
It will dispose of it. Mr. Nath, we are interfering with the orders. We are remanding it back, holding that the materials for basing on which your such thing was arrived at without notice was not considered. We leave it but to the authorities.
Yes.
To take, we'll interfere, but we will leave it to you
Yes.
to take any steps against them in a manner known to law. Right? Dispose of. Yes, Mr. Sirkin. You, I think we have the transcript of what Mr. The AG has done. So you can continue from there.
Now, gist of the submission, what I could understand, my lord, he has proceeded saying that
He has basically said we have not examined the matter.
agreement prescribed the period.
Period that is gone. So we said your period is over. Whatever you have done, you may have done, but we have not taken cognizance of that.
That is the circumstance.
And he relies on that director's note to that extent.
Now, firstly, my lord, the service of the petitioner, my lord, it is governed by a set of regulation.
Hmm.
And the agreement is a creature of that regulation. And the regulation doesn't prescribe that the period will come to an end once the period mentioned in that the agreement would contain a period, and once period prescribed is comes to an end, the service will be terminated or the person will be released. That power they don't have. And on the contrary, under the regulation, the continuation is a rule, continuation of the service. That's it. Let's see, I may have this regulation.
Mr. Sokia, this argument of yours, okay, but that is not pleaded. There is no pleading to that effect. Pleading in the repetition to that effect. That the prescription of a time limit in the agreement is contrary to the regulations.
I'm not challenging that, Mother. I'm not challenging.
Why I'm saying so? Why I'm saying so? Because just something came up, I'm just disclosing. You signed that agreement, not this, but regularly. You were signing agreements. So you have subjected yourself to that.
Yes.
So
Yes.
today, whether in that view of the matter, you can say
Yes, yes. But
whether
even
this is-
That's what, my lord. In the agreement also, what is said, my lord? Till this period, it will act as a so-and-so FAO of the, in the
because
poster,
all the appointments therein are contractual appointments.
contractual. In fact, the entire services,
Is this
there are
contractual?
two mode of recruitment to the
Deputation, contractual.
deputation contraction, and rule is applicable to the both. Different sections are
Hmm.
there, my lord.
Hmm.
The agreement merely says from this period to that period, it'll be act as a FAO at Dibrugarh. It is not that this is the only agreement. From different time, my lord, I have been posted with
You have
different
been signing agreements from
signing
time to time.
agreement. Yes, my lord. But that is not the end, my lord. Because the rule, what the rule says, your lordship will see, my lord.
Where is the regulation?
I think a copy was.
Yes,
Is it available, my lord?
yes, regulation copy, sorry.
Yes, yes.
Page. You are referring to 8A.
That's it. My lord, before that, 7, my lord. Before that, your lordship will find general terms and condition 6 and 6O. All contractual employee will have to sign an agreement.
Yes.
Now, 7, you also will find reversion or discharge. First is with regard to the matter deputation and attachment. B is the engaged on contract service. Person engaged on contract service for a specific period under an agreement shall also be liable to be discharged, released from Assam if he fails to discharge duties satisfactorily and as per terms of contract. So this matter attracts the matter.
Mr. Sokia, one query. 7B, whether it is contemplating a period within the agreement or it also contemplates a period after the agreement.
I'll come to that. This is definitely during the
Contract, subsistence of
subsistence
the
of the
agreement.
contract. Yes, madam.
Okay.
Now the 8, you'll also see 8A.
Hmm.
After successful completion of agreement on or deputation, mission director will follow following procedure and arrange for continuation of employees on deputation attachment and further engagement of employees on contract in mission service. EC will be informed once in a year regarding deviation made, if any, from prescribed process for continuation. Number and categories of employees who have been allowed to continue in mission service. Now, the next page, your lordship will find what is the procedure, my lord. It is the review and comments.
Hmm. Yes.
Now, serial number 9 is the accounts officer, my lord.
Chief accounts officer.
Serial number 9, my lord.
State level.
Serial number 19, my lord. Serial number 19.
Okay.
Accounts officer.
Accounts officer.
My lord, so far as continuation, review and comments on the performance by
Chief
CAO for serial number 19. Decision on continuation of the employee on deputation attachment and further engagement of the employee on contract basis, on contract in mission service by MD. So there will be a review and comments by the CAO at serial number 19 for serial number 19, and decision will be taken by the MD whether it will be continued or not.
Hmm.
So this is a rule.
You were a finance and accounts officer.
Finance and accounts officer.
That means it will be covered by 42. It will be covered by 42. Next page.
Exactly. Yes, yes. 42.
So here the comments of the CAO is not required. It is directly the MD.
Financial. No.
You are a FACO, FA and AO.
FAO,
Finance and accounts officer.
finance and accounts.
So you'll
officer.
be covered by 42.
Lordship, my lord. On
You're not a
42.
state level post, you are a district level post.
Okay.
So the decision on continuation of employees on deputation and further engagement of employees in contract in mission service by MD. So there is a difference
No,
between,
that is the decision.
no, there is a difference between the wording
Yes,
or
yes,
the
yes, yes,
process.
my lord. My lord, here what will be there, my lord? Collection of self-assessment report.
Hmm.
Then review and comments on the self-assessment report by DMC and concerned SPOs, SPE, CAO. Then decision on continuation of employee on deputation attachment and further engagement of the employee on contractual in mission service by
By the
MD. So
Okay.
self-assessment report and review and comments of the self-assessment report by DMC, and then decision will be taken by the,
Final decision by the MD.
but the condition precedent that self-assessment report.
But Mr. Soikia, in a given case like yours, wherein there had, I'll not say an allegation, there had taken place an incident which kept you out. Which kept you out. In such a situation, are the authorities of the SSA so disempowered that they can take no steps,
So yes, well, if they would have,
provided they don't attach a stigma to you?
Yes.
If there is no stigma attached, this court may not be in a position to come in.
yes,
If a stigma is attached,
that's it.
then yes, we will have to.
That's it. Now, my lord, if they would have considered, my lord, this particular process and they have come to a conclusion that I am not suitable, then they can discontinue.
Mm.
That is one aspect. Then, my lord, 311 or the other provisions would not come, my lord. And while, my lord, considering this assessment, if they would have considered that this allegations is also there, so therefore continuation is not, without going into the, my lord,
And I think they have done that only.
they have not done, they have set up an inquiry.
Mm. But they did not
They-
go into that. There are decisions.
Yes, they are decisions.
Mm.
But what they have this MD's remark,
Mm.
he has construed the allegation and thereafter he said,
Mm.
be that as it may, will terminate him. So, but therefore, my lord, this particular allegation is the foundation. Otherwise, from the affidavit also it would appear, my case was my lord, forwarded for
But they gave you a show cause to that extent.
to that extent. I have replied.
You have replied.
Roger. I have replied. And the so-called the decision that has been taken on the basis of the reply submitted by the another delinquent officer, Dipti Gogoi.
No, she was Dhanti Gogoi.
Dhanti Gogoi, my lord. Dhanti Gogoi. They have not considered my reply.
They say they considered both the replies.
But so far as my reply is concerned, I have clearly revealed how I am not
That is a different thing on merits.
on merit.
Merits.
But they have not.
They have considered both the replies and then they passed this.
Lordship, my lord. Now, while they have considered that, my lord, the report of the Dhanti Gogoi, my lord,
Hmm.
I should have been given an opportunity. So my submission is that this is the foundation.
And according to them, it can only be a motive.
Had they been considered for the purpose of review, and then this particular allegation would have been in their mind, and then they have relieved me, that would have been a motive. But here they have set up an inquiry to find out the allegation, and according to them, I have committed some offense, but without going into the allegations therein, they have given that matter. Now, second aspect of the matter, Lordship will see the agreement.
Page 26.
Lordship. Page 26. clause number 1, my lord,
Hmm.
that on and since the execution of this agreement, this second party shall act finance and accounts officer of accounts SSA Dibrugarh component in district mission office SSA Assam under first part up to, that is blank, subject to continuation of the scheme or subject to earlier termination either on ground of their unsatisfactory performance or on medical or disciplinary ground or on attainment of normal age of retirement. Further, those who have already attained the normal age of, this is not.
Now, does the regulation prescribe anything or a modality wherein an allegation, a disciplinary misconduct is
Okay.
available against
This
an-
is, your lordship will find, serial number 2
of that agreement?
is agreement. Lordship may skip A.
Hmm.
Then the party of the second part. Subpara of clause 2A.
Okay.
The party of second part shall submit yearly progress report on timely implementation of activities in relation to component. First party shall make proper assessment. The performance of the second party. The second party shall endeavor and strive for contributing towards the fullest achievement of
You can come to clause 6,
target.
page 27.
Yes, ma'am. This is with regard to the application of the Assam Discipline and Service Rules.
No, first party has to terminate the agreement at any point of time due to misconduct, insubordination, dereliction, misreporting, misappropriation, shall proceed in terms of the order dated 14/8/2015. What does 14/8/2015?
Yes. ma'am. This is at page, this one is page 29. The spirit of the Assam provisions of Assam Discipline and Service Rule will be applicable. Page 29.
Okay. Hmm. Whenever an inquiry is required to be held, they'll have to follow the provision spirit of.
Spirit.
So spirit would mean the entire application of the provisions of Rule 9 or a notice and a reply.
My lord, that would, my lord, if they, my lord, satisfied with the or dissatisfied with my report,
They'll
perhaps
have to proceed with the.
they may proceed or otherwise. But here in this case, they have relied on the report of the inquiry committee. They have relied on the statement of the reply of that's Dhanti Saikia, Dhanti Gogoi. So in that case, my lord, the principles of natural justice or the spirit of these rules, my lord,
Where violated.
my lord, the allegations, if I am not given an opportunity to substantiate, if that is taken, my lord, it will be definitely a clear, my lord, violation of principle of natural justice, my lord. Now, why I am referring to clause 2A, my lord, what it says, my lord, let us say again, my lord, the entire clause, my lord.
Hmm.
The party of the second part shall remain in contract from the date of signing of this agreement. The party of the second part remain duty bound, carry out the works assigned by the first party in accordance with duty chart or respective corporate designated set of contract period as enclosed herewith. The party of the second part shall submit yearly progress report on timely implementation of activities in relation to the component. First party shall make proper assessment on performance of the second party. These are the review, my lord, what is indicated in rules 8A.
Now,
That will be sales assessment report and then the assessment by the DMC. And then if they find, my lord, something wrong with my service, then it is followed later on, my lord.
Mr. Sokia, is it your submission that the agreement being in place, both are bound by that agreement, you as well as the employer? So now that agreement having specified a particular mode for doing a work, and that mode being the regulation, serial number 19 or serial number 42, ignoring that or giving it a go by, they cannot proceed.
Different. And the second aspect, my lord, the regulation provides only for execution of the agreement. It does not say that time will be specified, I'll be out. No, even when the agreement doesn't say so.
No agreement, there is some 11 months, something I found.
11 months, that is, I'll be acting, my lord. I'll be in charge
And Mr.
of a
Soikia,
particular,
Mr.
of a
Soikia,
particular
this is
post.
not the first agreement you have executed.
Yes,
You have been executing series of
series
agreements.
of.
So I don't think so that will lie in the mouth of the petitioner. To that extent,
Lord,
that the
No,
period
these are-
specification.
these are the, of course, my lord, I cannot say
This
that,
is a
but
mode
this
which
is
has been,
basically what,
this is a method which they have
what
put in
the,
place.
Lord, I'm sorry, madam, I'm sorry.
No, this is a method that they have put in place
Yes,
and they follow that.
Lord,
And you have been also following it.
following it.
And
But-
there is no challenge to that.
And how these agreements have been executed, my lord? Initially, it was 5 years. Then, my lord, from year to year, and sometime, my lord,
11 months.
11 months. And that is the reason lordship is aware why this has been done for 11 months. And it is not that after a lapse of this particular period, the service are automatically terminated. We are allowed to continue. And the official formality, they send the report and the assessment, whatever they have for the authority to consider for further continuation.
A, B, C, D, E. E means out. A, B, C inside.
Inside.
And A and B will get some extra money in the next agreement. That's, I think, is the scheme. E, if you get grade E, you are out.
Okay.
But A, B, and C, yes, Mr. Bora, that is the grading you make. A, B, C, and D. Yes, that is the grading. E means you are out.
Yeah, yeah.
Okay,
So,
got it.
So, my lord, though the regulation does not prescribe, this agreement prescribes what, my lord? That, my lord, second party shall endeavor to strive for B, my lord, the second party shall endeavor and strive for contribution towards the fullest achievement of target qualitative and quantitative as sent by first party during ongoing financial year. In case of any shortfall, the second party shall be duty bound to give specific reason, plausible explanation for the same. The first party seeks explanation for it. If the written explanation of the second party is found not satisfactory, the first party may ask to improve performance as well as to improve himself, herself for forthcoming financial year in terms of quantitative achievement of his or duty, or can discontinue the agreement henceforth, depending on the nature of underperformance or misreporting of non-committed attitude to work in mission. This is very important, my lord. Reason must be specific, why it will discontinue.
Okay.
And now in the affidavit, you also will find it is a regular process that persons are working, the agreements are sent to the authority for its renewal, etc. It comes after 6 months, it after comes after 10 months.
That's accepted.
So
That's
here in my case, it is also admitted that my report card was also sent. So that is not the after the incident that had taken place. This is my performance during the last year. Or at best, it will be up to the last date of the agreement, that is my lord, 30th November 22. Now
there is no allegation against you till that day.
till that day, nothing was there. Only
No
allegation.
further agreements were signed. This is the last agreement signed.
This is the last agreement. This was on process. This is admitted. In the affidavit, they have admitted, my lord, in paragraph 17, that it is a fact that the process for, my lord, agreement was forwarded
going.
for further continuation.
Because the allegation against you that occasion sometime in May, June
Yes, yes.
of the next year.
Next year, my lord. Here, though it has expired in 2022, the affidavit was filed, my lord, on 21/7/23. Till then, it was not complete. And in paragraph 17, what they say,
Page 62.
page 62. The answering dependent category affidavit denies the malafide action with regard to petitioner, and upon lapse of the agreement on demand, the writ petitioner is released from service. That employee under SSA have been allowed to continue in service notwithstanding the expiry of the agreement period as on expiry. His case for further engagement was under consideration. However, it would not give rise to the individual right to the writ petitioner to be continued in mission service beyond the contract period, in as much as mission director SSA has decided not to further engage the writ petition on contract mission. Then paragraph 18, that as regard the statement made in paragraph 19 and 20 of the writ petition, the answering deponent begs to state that contention of the writ petitioner is misplaced and misconceived. Who was engaged on contractual terms. The contractual period has expired way back on 30/11/22. Further, the mission director, Assam, is well within its power to decide as to further engagement of writ petition on contractual basis under mission director. As per service regulation and financial regulation 2003 under regulation 8 regarding further engagement of employee on contractual continuation as to post of finance and account officer, which was held by the writ petitioner, is at the discretion of the mission director. Lordship has seen the regulation. It is not the discretion. It is not that he wants, he likes me, he'll keep me. He doesn't like me, he'll throw me off. The procedure to be followed. And this is the stand in the affidavit. Now, at the time of hearing, what is it to say?
Mr. Sukya,
Lordship,
one query. Now, you have taken me through the stand, you have taken me through the provisions of 8A. Now, any examination that is contemplated in 8A would be limited to the period of the agreement.
Self-assessment report
No.
on the basis
I'm
of.
not on that.
Lordship,
Not on that. If you can come back to clause, just I'm digressing a bit.
Lordship,
8A.
8A.
O says all contractual employees will have to sign an agreement. So that agreement may be for 1 day, maybe 1 year, maybe 5 years, whatever it is. After successful completion of the terms of agreement or deputation, we'll follow the procedure and arrange for continuation of
Yes.
deputation, so and so, so and so. Now, this continuation would be by a consideration of the period you have done in terms of page 26, if I'm not wrong. Yes, till 1 January 2022 to 30 November 2022.
Right.
So the consideration,
That is the period.
because the consideration would be as of 1 December 22,
22.
whether you will be continued. Now, tell me, is it the case of the petitioner that any consideration for extension of my agreement would have to be limited to that period only? I'm asking it with a purpose. Because you don't have an agreement from 1/12. Why I'm telling you?
Yes, yes,
You don't have an agreement from 1/12.
yes.
So let's see, say you were given an agreement, a deemed agreement. Then this incident happening in between, sometime in May, June 23, they ought to have applied the clause 1 following that 14/8/15 letter. Am I clear? Any service satisfaction that can only be for the period till November 22. Beyond that, they can't do that. That your service is not correct, bad, they can't do it. Your argument is that you have now, by taking recourse to the actions or the allegations that came to surface sometime in 2003 after March or March, April, whenever, you cannot now decide my continuation from 1/12/2022. Is that the projection you are trying to make?
I'm just. What is appearing, in my understanding from the rules, self-assessment report and for continuation is always with regard to the past service. That is one aspect. It is only the bulkness of the voluminous task of
The people, number of people involved.
voluminous task for execution for renewing the agreement. So it takes time, but otherwise these are continued.
No, that is what I'm asking you. This continuation, say they do it after 6 months. Is the agreement entered from a date after 6 months, or is the agreement entered again from 1/12/2022?
From 1/12. They do it that way. Therefore, your lordship will find
So if the agreement is to be entered from 1/12, there is no allegation against you on 1/12.
nothing.
Now tell me. Okay, there is no allegation, but the process was pending. These allegations come to their notice and they decide, okay, we want an employee who is overboard without any allegation or anything, no suspicion, nothing. So we are not extending him. What do you have to say on that aspect?
My lord,
Forget what they have done.
generally, even if it is an ad hoc or contractual employee and appointed against a scheme, there is, my lord, always, my lord, they are to continue till the expiry of the scheme or till the, my lord, the scheme subsists. Unless they are, my lord, terminated or otherwise, my lord, superannuated or whatever, my lord, reasons prior to that. Otherwise, they always have the, my lord, right to continuation of that, my lord.
That would be my second line, which I'll ask you. But I am now on the question that if your agreement is to be renewed from 1/12/22, there is no allegation against you. I'm neither taking a view nor I am this is just a query. There is no allegation against you. So any allegation which came, say, during the processing of that matter with prospective effect, if I may just for clarity, prospective effect. You may have defalcated money for a long time, but that came to light, say, in March, April, or May. Whereas your agreement is to start from 1/12. On 1/12, even if you had defalcated, that was not to the light of anyone. That was not to the knowledge of anybody. In this situation, what should the action be? Whether they have to go back and enter into an agreement with you as of 1/12, and thereafter, as of the date the allegation comes to light, take action against you.
That is. Another what, my lord, I've been trying to, my lord,
No. Are you saying that this is the correct way to do it?
or here, your lordship will find, my lord, the affidavit that has been filed first.
Forget the affidavit.
But no,
Forget the
here,
affidavit.
because
They have said that. I'm not going into that.
Okay.
I want your perspective on that, so that I can adjudicate on that. I want a perspective on that.
I am only, I just wanted to, I mean, what I said, my lord, that Gill's case, I wanted to.
Mohinder Singh Gill, forget it.
Lordship.
We are not even
Lordship.
giving any credence to that.
Lordship.
But I want an answer. Your agreement has to start from 1/12. No allegation against you. Are they duty bound, even if there is an allegation which comes during the processing? Because you also admit that it takes 6-7 months to get the thing done. So is it your case that you cannot? You will have to enter into an agreement with me from 1/12/22. Thereafter, something comes, you take action. 1. 2. In absence of an agreement, in the 2O and 6O and 8, there cannot be a situation visualized in SSA wherein a person is continuing without an agreement. An agreement is a must for continuation.
My lord, agreement is a must for continuation. I don't find it, my lord.
That is what I want from
That
you. Just show me that where I can
What is-
conclude
My lord,
from which
what is
I
not-
don't want to make an interpretation. I want to make a conclusion.
Lordship.
That these two provisions lead to a conclusion that the persons are there till they are removed or superannuated. They will continue.
Yes.
Unfortunately, 6O and 8A does not give that indication.
Well,
Because 6O says everybody will have to sign an agreement.
that's it.
And you see the wording of 8A. After successful completion of the terms of agreement or deputation. So there is a concept, they have conceptualized one thing, that the agreement will be for a specific period. And thereafter, the rest of the part will take over. And then you go to 42,
That-
say 19
yes,
and all those
yes.
things. So there cannot be a situation that a person can continue without an agreement. There has to be an agreement. And if there has to be an agreement, subject to my first query,
That's it.
whether they have the right to say, no, this man is not a civil servant. So 311 directly not applied. We don't want him.
Well, my submission is that my appointment order has been issued after due selection attitude. Then I am to join. And one of the condition I have to enter into an agreement. That is one of the condition among the various conditions. This agreement cannot be restrict the period of service. What, my lord, the
I'm sorry, Mr.
no, why,
that's not going in.
Why I am saying, my lord,
Because 6O and 8A does not give that impression.
why I am saying, my lord, even if your lordship looks into the agreement once again, my lord, that on and since the execution of this agreement, the second party shall act finance and account officer of accounts SSA Dibrugarh. I'll act as a so-and-so.
So fine.
My appointment is already there. My appointment is already there.
No.
This is an
See, subject to continuation of the scheme or subject to early termination. The agreement will automatically lapse on 30/11/22.
agreement would lapse, not my appointment,
That's it.
not my service.
That's it. That's it. 6O requires all contractual agreement employees will sign an agreement. And 8A requires that after successful completion of the terms of the agreement or deputation, what is to be done? So you are continuing in your services on the basis of the agreement subject to satisfactory service. It is not a that the continuation is the norm.
That's what I said, my lord. Continuation is the norm. That's what I said, my lord. Subject to, my lord, this performance. Subject to performance. And how the performance will be judged? It is a self-appraisal report and the report of the DMC, and then decision will be taken by the MD. So self-appraisal report will be definitely of my past service.
Past service. That cannot
your
be,
lordship,
that is service till November
aspect-
2020.
Another aspect of the matter, lordship will see, after expiry of the term of anything, my lord, there cannot be any extension. There cannot be any extension. So it has to be during the period. Now here, because of the voluminous or bulkiness of the things, it takes time. This is a mere formality that goes. If the report is there, that it is adverse and his term cannot be continued, in that case, he is discharged, and for the works he has continued, he'll be paid and said, for your services, we could not continue since you have worked, you go.
So in that view of the matter,
Otherwise,
your services also have been considered in that line. And then the authority comes to a conclusion because of this, something is there against him, which we don't desire. But we are not going into it.
They are not saying that my services were unsuitable or not.
They are saying the final wording is.
They said these are the allegations against him, serious things, but without going into the allegation, his service will be discontinued. My suitability has not been assessed.
From the above so and so, that though it is noticeable that there is serious allegation of financial irregularity, misappropriation against so and so, for their, however, without going into the truthfulness of the allegation against the both, I being the appointing authority do release so and so from the contractual services on account of expiration of the above noted deeds of agreement on 30/11/22. Ordered accordingly.
My suitability has not assessed by that.
But if your agreement is over on 30/11/22, hypothetically, legal fiction, you're not an employee on March. So how could I have taken this decision on a issue which arose in March?
No, that's what I said, my lord. This is an bulk test of the things they themselves has admitted that all the other day also said out of 30 have been continued, only
29 has been continued, 1 has been out.
one has been agreed. So this is the process. The signing of the agreement is a mere formality. In some agreement, I had, my lord, the period is for 8 months.
Any decisions?
My lord, over and all, my lord. The other day also I have referred one of our judgment, my lord, where it says, my lord, it says civil post and attracts 311. At that time, disciplinary and appeal rules was not in the spirit of the appellant's rules were not, my lord, brought in. But now it has also been brought in. So that protection, both the protection, the petitioner ought to have, my lord, given. And the fact,
I think you have referred to the case of Arun Kumar Roy.
my lord, I refer to Sahidur Rahman, my lord, 2017 1 GLT 528.
Paragraph.
12 and 13.
Okay.
And the whole of a thing, my lord.
Where is your initial appointment order? It's not on record. Oh, yes, it's record. Page 24. Okay. Now this question whether this is a civil post. Okay, we have a decision. Is FRSR applicable to you?
Generally, when rules are silenced, the FR and SR are, my lord,
No, that has to be adopted. Because this is not a direct department of the government.
sir, my lord, scheme implemented.
Society.
No, my lord, that's what, my lord. The government of India money, it has been given, Assam government as an implementing agency. For the purpose of smooth working, they have created a society.
That's all.
But all the officers, all the control, everything with the state government.
So how can you call it to be a civil post? Civil post.
That's it.
How can you call it to be a civil post?
It's after all, my lord, originates from the government of India fund that has been given, my lord.
You don't have a status of a government servant.
I do not have the, my lord, that's the, my lord, two, my lord.
Otherwise, if it was a civil post, then the provisions of the discipline appeal rules would automatically apply. There was no requirement of its adoption, that to this spirit.
Yes.
Okay.
Two, the 311(2), my lord.
311(2) also will not, because that would be the other part. The word used is civil service of the Union of India or a civil service of a state or holds a civil post under the Union or a state. So you are not holding a civil post. So 311(2), you will have to demonstrate that you are holding a civil post under the service of a state. Okay.
3 may come into 3 minutes, 311, 3 minutes. That is again in respect of any such person or person.
No, that is not even that is not even, there is no pleading to that effect. Is there anything in that 2017 judgment to that effect, that how it has been held to be a civil post?
Yes, I'll check. I have a copy, I'll forward it.
Have you extra copy?
Yes. Paragraph 12, minute 12.
Only paragraph 12, there is a reference that it's a civil post, but there is nothing as to how it is a civil post. There are decisions which delineates what a civil post means. Anyway, don't worry, we will do it.
It is an statement that the society itself is an statement.
Because of that financial control
Financial grant
and the administrative control.
administrative and the job it
But
is.
will that by itself make the post a civil post? Maybe you have an access to this court. Although it's a society, you have an access to this court.
Right.
Otherwise, if it was not having that Ajay Hasia and all those
Yes.
pervasive control and this. Any more judgments, Mr.
Yes, yes. From the pleadings, my lord, of the parties, my lord, what, first of all, my lord, I said, my lord, they say they have two set of, my lord, initially they have said it is just the power, my lord, is discretionary on the MD. So therefore, on expiry of the term,
That was a simple case taken.
simple case. Now, subsequently, another FIR they have filed, another affidavit in opposition, additional affidavit they have filed.
They have developed that case.
They have
From
developed-
Mohinder Singh Gill.
The other day also argument was that principle of natural justice has been complied with because he was given a show cause notice.
But unfortunately, this down below part, that show cause notice was not even considered.
Not considered. And my reply, and the statement of the other whose Miller was, they have found that the allegations. I was not, my lord, I did not have the opportunity to cross-examine anything.
Okay, now give me your judgments.
So therefore, my submission, the mayor order, the wordings in the order, my lord, is not the sufficient, my lord. To find out the actual reason, the court has the power to, my lord, lift the veil. And if your lordship finds that ultimately, though the words are, my lord, innocuous, but then it flows from some misconduct or some dereliction of duty, whatever.
Foundation or motive.
Yes, then in that case, it will be a foundation. And if that is a foundation, it is an stigmatic and
Automatically.
will go, my lord. That is the under basic submission, my lord,
You can give me the citations and the paragraphs.
lordship, my lord. My lord, 2004-11 SSC 743. Well, I just refer to AIR, my lord. AIR 2004 Supreme Court
AIR 2004 Supreme Court
4655.
Party.
State of Punjab versus Balbir Singh.
Okay.
Then 2000 AIR 2000 Supreme Court 1706.
Hmm.
That is party's name Chandra Prakash Sahi
Sahib.
versus state of EP and others.
Hmm.
Refer to paragraph 12, 28, 29, and 30.
Hmm.
In the first one, my lord, I refer to paragraph 7. Then Shamsher Singh versus State of Punjab. AR 1974, Supreme Court 2192.
That's the starting point.
That's it.
AIR,
1974, Supreme Court 2192. Shamsher Singh versus State of Punjab.
Hmm.
I'm referring to para 80 of that.
Anything more?
My lord, factually, I would like to submit something. What is the reason, my lord, they have pushed me to this, my lord, place, my lord?
Hmm.
The first notice they have asked your lordship will find that what is your explanation that this file is not available, which is in your custody? I said it, I am not the custodian of this. I cannot have an,
Yes, you have taken me through that last time.
yes. So that is the first. I have replied to that. Now, I have been arrested. Police has searched my home. I have been detained, and they have searched my home as well as the office.
They have not got any incriminating material.
But that has been found. The police has seized it on 29/9/2023. Police has found the same from the office of SSA.
No, I think DMC, district office,
SSA office, Dibrugarh.
Dibrugarh. That means the office of the district mission coordinator,
That's it.
DMC.
That's it. So the initiation was that, where did I keep the file? It is in your custody. It doesn't remain in my custody. That they have found, number one. Secondly, the period of allegation, your lordship may kindly note. The period is, my lord, January 22 to April 23. At that time, my lord, this Sanjay Datta, he was the district development commissioner of Dibrugarh, under whose, my lord, supervision all the allocation of funds, etc. are there. He has been transferred on 5/11/2022. He is very much involved in that particular area of period. Whether he is involved or not, but he was there as an officer during.
Will not go into
why,
the merits.
no, that person, why I'm submitting, this person has been transferred. Not only he, the district mission coordinator is also transferred to Guwahati, my lord, on 30/12/22. I'll just give the copies, my lord.
No, I'll ask
These
you.
are the persons who have been removed from the area for an, my lord, proper inquiry. He was posted somewhere, my lord, and then, my lord, this Sanjay Datta was brought in as a, my lord, executive director here. He has sworn this affidavit.
Okay. Now, Mr. Soikia.
And it is also, the other day said I had been detained in more than 48 hours. It is not correct.
You have not been detained for 48 hours.
No, not. Therefore, after the release of the, my lord, from the detention, my lord, on bail, I joined the office.
Now, how long were you in detention?
Less than 24. I was, my lord, arrested on 10 and I have been released on 12. Less than 12. Less than
Bail order is of 11th.
12, my lord.
12th.
12.
And the same day you were released.
No, 10 is the date of arrest.
10.
It did not exceed 48 hours.
48 hours.
So they have allowed me to join. Only what they did after my joining, they said.
Okay, got it. This things what you have argued, can you just reduce it into writing in a page or two so that I can, when I can have it in written. Whatever discussion we had, deliberation, if you can just put it down in a page or two. One.
They just don't want to hold the inquiry. If it is, my lord, and any inquiry, even this disciplinary proceeding is held,
we'll facilitate.
I'll unearth.
We'll think about that. We'll think of that. That's something troubling. We'll think about it. Now today, I accept you. contingents. And I come to the conclusion that your removal was not proper. But given the format, the process that is to be followed, that's why I was asking you the first query. That agreement, renewal, that is not there. And now these aspects have overshadowed all those things, which has thrown you shown you in a bad light. That Mr. Soikia is involved in these things. Now today, if I decide that no, suppose you were to be given an opportunity following that 15 notification by following the spirit of the Assam Discipline and Appeal rules, I have two options. One, to say that for the purpose of that inquiry, you would be deemed to be in service. And thereafter, on conclusion of that, if you are exonerated or anything, you get back everything. Second, normally that we follow when a government employee is before us, that reinstatement, suspension,
I'm
and
not
then
suspended.
reinstatement in service, suspension, and the proceedings come on. But you cannot be. Is there a provision for suspension of a contractual employee? There cannot be. There cannot be.
They
So-
had diverted my work to somewhere else.
Somewhere else.
They said
but
you don't be in this
in
charge.
this area.
Yes.
So
They can
that
always
again,
follow.
no, that again would be subject to people working, because we'll be under the presumption, or the presumption would be there that all the posts are filled up. So maybe immediately you cannot be taken back. What about the first proposition? What do you say about the first proposition? Even if we come to a conclusion, that balances both. The allegation, if it is true, a person like you may cause much more damage. At the same time, you have a grievance that you were not given a fair opportunity, and even given a fair opportunity, you would have brought to light many things, which, if true, would go to advance the working of the SSA authorities. What do you say on that? Think over it, Mr. Soikia. Don't come
Yes.
out with a.
Yes. Malad, I have to reiterate what I had submitted only, Malad. I showed your lordship the.
Because see, I can't put you back because that agreement, then I'll have to direct them to enter into an agreement with you, which at this stage, this court will not do.
My lord will find that the order is not proper.
We will not say that. We will say that the procedure followed to leading to that maybe has caused a prejudice to you.
So this order
So
has to be
that
satisfied.
has to, that order we will eclipse it.
No.
But putting you back,
Lordship may not spell out anything, but the law will take its own course.
no, that would again give rise to.
No, why I'm
problems.
saying it is again in your lordship mind that the allegations are very serious.
I'm not on that. I'm not on that. I told you I have two opinions on that. One, if the allegations are true, which we can't say, then the organization with a person like you inside more damage may be caused. Two, as you say, that see, these allegations, if I was given an opportunity in a proceeding to counter, I would have brought on record the actual facts. Right?
Yes,
So that would be beneficial to the
Roe Borali would have come.
row morally, everything would have come out.
Yes.
So that's the anxiety. Think
Therefore,
over.
therefore resistance to this writ petition is
That-
very high.
This
Even after concluded, then again the arguments have been initiated. So resistance is very
I know that. Resistance, I'm not worried.
large.
But I am worried as to how to move forward. As an officer of the court, I want you to apprise me on that.
Yes, my lord.
Mr.
for a
Soikia,
moment,
forget the case.
For a moment, leaving the allegation, everything aside, my lord, so far as what my understanding from there only I am saying, my lord, the appointment is first, agreement is subsequent, and the agreement does not say that on.
I'll defer with you there. The order of your appointment says you are engaged, subject to, and now that's what I'm asking.
That's it.
Without an agreement, you cannot survive.
Yes,
The scheme of the regulation
Yes,
does not contemplate that. So an agreement is a sine qua non
No,
for you to
yes, because that is,
continue.
yes, that is one of the condition in my appointment as well as in the regulation.
It's not an appointment, it's an engagement. You were not appointed, you were brought over. Just see the fine language there.
Yes, yes, yes.
Because I'll have to write a judgment, I'll have to lay a proposition here.
Lordship will definitely,
That's what is troubling me. On the result, so and so are engaged on contract. So and so, with effect from the dates of signing of their agreement.
again,
So this appointment, or we'll call it an appointment, no problem, is not the starting point.
signing of the agreement.
Signing of the agreement.
And the agreement does not specify that it will be for 10 months, whatever, my lord.
That need not be, because 6O and 8A read together brings to the forefront that this is a time limit. There has to be a time limit. It can be 1 day.
No, but then, my lord, the procedure.
If they like your face, it can be 5 years. If they don't like your face, 2 years or
Yes,
1 day or 1
yes.
month, whatever it is.
Yes,
But a period will be there.
yes, my lord, the practice also sometime, my lord,
We'll
overrides
have the force of law.
Yes,
We'll for
yes,
understanding.
sometime, my lord, overrides the rule also, my lord. Here, the affidavit statement I have shown, my lord. All the agreements have been sent for, my lord, it is filed in July 2023. All the agreements for sent for renewal, but that does not give rise to me of a, my lord, for continuation. That's what they said. That means that is the practice what has been followed. Otherwise,
Their affidavit is clear to that extent.
from 112.
Para 17 middle portion, that is the contention, that this was in process, this came. So we took this
No,
decision.
they don't say so.
No, but
They don't say so, man. They said that it is discretion. Continuation is discretion.
Hmm.
They don't say anything. They don't spell out anything with regard to this misappropriation or whatever, those allegations.
they did not bring that note, that note of the mission director
No, man.
here.
Yes,
That was brought on record in the
Yes.
proceedings.
that's all.
Okay, when can you give me that note? Tomorrow? Day after?
Yes, man. Tomorrow I'll try, or day after.
Day after, well, let's put it Thursday. But if possible, wherever, this is a query I'm putting you as a senior counsel. If I come in your favor, what should be the result? If you can get me a judgment or two on that. How do I proceed in a case of a contractual
My
appointment?
lord, I cannot put the words into your lordship mouth, but court's limitation would perhaps be completed once the order is found to be legal and set aside. The rest, always the authority will have the power, etc., to act according to them, my lord. They put me in suspension, they reinstate me.
I don't want you to come back with a vestige left behind by this case. You come back with a fresh cause of action. Otherwise, if I put it at that level, you not having an agreement, continuation, they will say, we have not entered into an agreement. You will again come back to this court by way of a contempt. Another year will go, and thereafter some decisions would come. Why not at the first go itself settle the issue, either this way or that way? So there is a finality, clarity as to what to do. Even if we
Yes,
put you
yes.
back, how we put you back. And if we don't put you back, we don't put you back.
My lord, they don't say that I am not in service after 112. My lord.
That is what I'm asking.
They don't say, my lord.
That
They
is why
say-
my first query,
In fact, I
Mr.
have been paid also. When I have taken
Mr. Soikia, my query, that if there is an agreement from 1 to 11 months, it will cover the period of the allegation against you when it surfaced. So then it would be a action which they ought to have taken under 1A.
But the consideration would be, my lord, the service I have rendered prior to
I'm not on that. That's what I'm saying.
2011-22.
They, if we follow the norms as they follow, they ought to have signed an agreement with you from 1 to 112. And thereafter that agreement would be deemed to be continuing on the detection, your arrest and all those things. then it would be 1A. But here that did not occasion, or there was no occasion for proceeding in that connection, because by that time steps were already taken. And you did not approach this court at that point of time. You approached this court
Yes,
after the actions were taken.
Well, the order was not served on me. That is another aspect. Order was not served on me. I have come, well, I have prayed for an interim order, but then court thought it to
Okay,
consider the interim
fine.
prayer at a later date.
Because that would be giving you the final value.
Yes,
at
in
that
the
point.
meantime, affidavit and fine.
Okay,
everything
fine.
is returned.
Day after tomorrow. We are fixing it for day after tomorrow.
Right.
And if you can get me something on that lines, I'll be very happy. That final order, if I come to that conclusion that you have to be put back, what would be the options open to me? In this given situation of a contractual employee? Because you can't be placed under suspension. Concept of suspension would not come in. Just if you can think over it,
So
Mr.
they have been doing the transferring also. They have been transferring person from one place to other place.
But again, you will be put back in the same job.
Not necessarily, my lord, the.
You will be accounts man, you will be looking after accounts only. Where can you? Because you have been scanned for that accounts work only.
Anyway, my lord, even the my lord Dhanti did not directly implicate me.
Forget it.
I'll not go to that.
Heard
I'll try to
Mr.
assist you a lot.
Heard Mr. PJ Swiggy. Just for my satisfaction, my clearance, that's all. Heard Mr. PJ Swiggy at length. So list this matters again on Thursday. 22nd, 2/5/2024. You can only for that purpose. There are, I'll preserve it. Mr. Bora, you have heard him. Anything is there on a counter, you can put it on the record. That. By slip, could you have come Yes, Mr. Islam has brought on record some additional affidavit. What is that? Has it come on record?
Yes, your lordship.
I see. What is that material you want to
My
bring
lord,
on?
kindly see, my lord, these are basically, my lord, routines of the school. And my lord, one document, my lord, at the time of a permission of the school, my lord, 2005 document, my lord. Page, my lord, 132, my lord.
Now tell me one thing. From where did you get 136?
My lord, is a my lord document, my lord, issued by my lord, DO of Dhubri, my lord.
How?
My lord, because pursuant to the document, permission was received, my lord.
97 document, page 136. That
My lord,
was that routine.
132.
No, one routine that is there.
Routine, my lord, 1997 routine.
How did you
19
get it? From where did you get it?
No,
Is it maintained in the school?
No, my lord.
Then-
It is from school record, my lord.
It's all the routines are kept maintained
My lord,
properly.
These four routines, my lord, which I have, these are
That
available.
we will know. Either the complete routine for all the periods are maintained or it's not maintained.
No, my lord, other document.
You cannot have selective.
Other, my lord, cannot be traced.
Will not consider that.
My lord.
Where have you stated that 136 corresponding paragraph?
136, my lord, page
Page
1.
136 corresponding paragraph.
My lord.
Para 4.
There are 4, my lord.
Why the selective copies are there, others are not there?
My lord, the 2014 onwards, these are, my lord, available on record, my lord, it's a continuous, my lord. Same routine, my lord, followed by my lord, the 2014 to 2018. And my lord, regarding my lord, the 1997 and 98, these routines are prepared by the earlier headmaster, my lord. So, my lord, these documents petitioner at present, my lord, trace out, my lord.
This is for 1 year.
2 years, my lord, 97 and
The
98.
one document here, 98, page 136, it's for 1 year.
Page,
It's an annual routine.
page 13, my lord, is my lord, same document, same routine followed by, my lord,
For the
14 to
whole year.
18, my lord.
For the whole year.
My lord. Because my lord, same stuff, same my lord, teaching stuff, same my lord.
Yes, Mr. Khan.
My lord, one submission, my lord.
Huh?
Well, these documents we do not know where from he has collected.
No,
Well,
it's your
he is-
school only.
He is annexing the
Your
document.
school only. What is his name? Where is he here?
My lord,
Page
in
136.
1998, after, in 1997, he was resigned. In 1998, his name is not available. In
97?
1997, his name is available.
Show me.
Subfuel hope, my lord,
SH, where is SH?
SS, my lord, in the, my lord, last column, my lord.
Drawing.
Last one, SS Subfuel hook. And other, my lord, the
Social
subfuel,
studies.
and in last from third column, from last, my lord.
Hmm.
Subfuel hook. Subfuel hook drawing.
Drawing.
And then my lord, social studies,
Class
subfuel hook,
6.
my lord, in last, my lord. From last three, my lord,
Social studies.
social studies, my lord.
Hmm. And where are you?
My lord, Abdullah Khair, my lord, English, first, my lord. Abdullah Khair, my lord.
Okay, Abdullah. English.
My lord.
So he is social
My lord,
studies.
and Abdullah
And
Khair
where
also
is
said,
Mr.
my lord,
Alda?
in 1997, his name is not available. my
Okay,
lord.
98, his name is.
98 also not available because, my lord, in 1998, he was appointed, my lord, as second additional assistant teacher. His post was not in existence. In 2007, he
Mr.
was,
Khan, do you want to respond to this or we'll close it?
My lord, already we have given the response.
No. This additional affidavit. Anything to say on this?
My lord, I have something to say, if your lordship permits me.
Why
my
not?
lord,
Yes.
My lord, in his own writ petition, paragraph lordship 16, lordship kindly. Here is the paragraph 16.
4564.
My lord, 4, 5,
Paragraph.
6, 5, paragraph 16.
Hmm. You
He
should have
changing-
given this to me yesterday.
my lord,
We came with a mind.
my lord.
Today now with this
He changing his.
16,
version. My lord, time to time, lordship paragraph 16, since the petitioner was the headmaster of the school, and as such, he taught all subjects. And the respondent number 9, lordship, is the lordship Safil Hall, taught only language.
which is again belied from the page 136. Safiyul Haq never taught, he was teaching social studies.
My lord, what happened the petitioner, my lord, when he, my lord, promoted as headmaster, he taught all subjects, my lord. Whenever, my lord, for my lord, my lord.
Now it is a case wherein you will have to go before the education fund.
Yes.
My lord,
You go and
lord, I
settle
may
it.
be
It's a
allowed-
very good document.
My lord,
Get
I
it,
may be allowed-
get it settled.
only short submission, my lord. Respondent number 9 have 3 appointments, my lord. One appointed in 1993. In 97, he was resigned. In 97, he showed.
Who is the provincialized person now? You are the provincialized. And
I am, my lord.
you are provincialized. Continue. We will ask you to go, make them parties. And we will require the tribunal also to ascertain whether they are entitled. We'll do that.
Well,
Go before the tribunal. These things in the high court, we cannot. How can I know what that 136 is?
My lord, may I submit one line?
my lord,
My lord, there is a principle, your lordship is aware, which is known as approbation and reprobation. He cannot play hot and cold at the same time. Your lordship will kindly see, in the writ petition, he has made his statement, he is English teacher. At the time of provincialization, he is English teacher. On the earlier proceedings, he was English teacher. At
Now
no
he
point
is
of
all
time,
along, he is in
at no point of time, my
I'll
lord, he
not call it
objected to
English, he
a
was a
provision.
language teacher all along.
Exactly, my lord. Language teacher. Now,
Being-
my lord, he cannot say that I am teaching all these subjects. So as to fit in, my lord, in some
Party-
circumstances.
Parties at length, Mr. Islam, Council. Council for the petitioner in WPC number 4564/2023 has brought on record an additional affidavit filed by the petitioner in the matter. Also, the same is taken on record. Also, the parties, the respondents in the present proceedings. You are Mr. Talga
My
Abdul
lord, I
Hussain.
am in the first writ petition.
First
Abdul
writ
Hussain,
petition.
481.
Abdul
Lordship
Hussain.
kindly, my lord, dispose of that writ petition, my lord. Yes.
Have no objection to the said additional affidavit being taken on record by this court. Full stop.
In fact, copy has not been served to me, my lord.
Copies are, my lord.
Mr. S.K. Talukdar, the writ petitioner in WPC number 4881 2023. You are 4881
My lord.
also has got no objection in the said affidavit being taken on record in as much as both the writ petitions are being heard analogously. Also, in view of the above, the delivery of orders is deferred till 8/5/2024.
My
We'll
lord,
pass
I have,
orders on
my
that.
lord, submitted one, my lord, judgment, which says, my lord, that if, my lord, he is not an aggrieved person, because what comes on record is, my lord, he is a, my lord, English teacher in language. Now, with respect to, my lord, my post, he is not an aggrieved person.
Mr. Talukdar,
Ma'am.
he is an aggrieved man because his service is not provincialized.
Aggrieved not in respect of my post, my lord.
Whatever it
also
is,
agreed, my lord.
in that school, there is a thing, we will work out something for you, don't worry.
Highly obliged.
My lord, reserved for judgment, my lord.
No, for delivery of orders on that day. And anything more, if there is something you want, might you get some ideas, you want to file another additional affidavit, I'll not accept
No,
it
my
on
lord,
you.
no.
Obliged.
Yes, Mr. Roy, the records are ready.
My lord, last night they mailed me some instructions, your lordship. I think.
No, you were supposed to give me the whole records, whatever you have.
My lord, the records, they have, because they are, everything is, because it's, there is not in service since 13 years, everything is digitized, they said, my lord, that's what. Next page is the brief, and then thereafter is other documents. Available
No.
from
What was the ground for this leave? That is what I
My
want
lord,
to know.
in fact, they, as regard the subsequent affidavit recent, they filed annexing a document.
Hmm.
They have given instructions, my lord.
Hmm.
Your lordship will find, they say in para 3, that he has been in under treatment since 5/11/2006 in the read petition under the same doctor. In read petition, in para 4, he said since 23/4/2008. That inconsistency, my lord.
That is why that's why,
That's
because
he has
he's
made
a,
out a case. The read petition a different case. Now he says some same doctor, Dr. Ghosh, 5/11/2006. So in read petition says different thing.
2008.
2008. So how can it be, my lord? And this they have also given instruction on this also. This
So
doctor,
how, from where was this medical
my
certificate
lord, this
available on your
doctor
records?
now he has given is a doctor, not a doctor in the ONGC hospital. He is in the base hospital from, my lord, where the the engineers work, my lord, for drilling and other purpose. The base hospital, from base dispensary or something. So it's not a, after that they said they have also asked him to go to the ONGC hospital. It did not appear there. I have stated in my affidavit also. Medical reference, with regard to the medical
This-
reference documents.
This medical certificate that you have brought on record
Oh,
of
that
2009,
is, he has given, my lord. Your lordship will kindly
this
see.
is basically gas,
Yes, walk and other thing.
Ondem, Sorviline, Gasex,
And the certificate,
scanning
my
of
lord,
the
will kindly
stomach,
see.
abdomen.
Certificate, your lordship will kindly see. It says since 2009, he has been suffering from other disease, not, my lord, the. And as regard the subsequent affidavit, they wanted to file because they said there is a lot of inconsistencies. If lordship can, I can file in counter to this. That is the instruction they have.
No, that's the instruction naturally. If this situation, how can you?
Lordship.
But don't just file an affidavit. We will want to have the documents.
I'll place these documents and everything on record by filing the petition, so that my land.
So he also gets an
Yes,
opportunity.
I'll do that, you know.
Can you do it before
Lordship,
by 7th or 8th?
huh? Can it go 10th, you know?
Before that, you will file it.
Yes.
Mr. Chakraborty, can you file it before 10th?
Next,
The 10.
10th is.
Mr. P.K. Roy, Learned Senior Counsel, assisted by Mr. S.K. Chakraborty.
Yes.
Learned Counsel appearing for the ONGC authorities have submitted that the records that were required to be placed before this court to ascertain the ailment suffered by the petitioner for which he was granted leave during the period from 2006, could not be made readily available on account of the fact that the services of the petitioners were
2009.
held to be, petitioner was held to have resigned from his services way back on
2009.
2009, your lord.
2009, and thereafter
16/12.
the present proceedings were only instituted
2014.
in the year 2014. So accordingly, Mr. S.K. Chakraborty, Learned Counsel, assisting Mr. P.K. Roy, Senior Advocate, submits that he be granted time till 9/5/2025 to bring on record the stand of the ONGC authorities with regard to the contentions now raised in the matter by the petitioner in the additional affidavit. In the affidavit that was filed by him in the present affidavit and reply that was filed by him in the present petition, as well as the medical reports produced by him during the course of the hearing of the present proceedings, a copy of which was handed over to Mr. S.K. Chakraborty for further. Was also handed over to Mr. S.K. Chaudhary. Full stop. List this matter again on 10/5/2024 for further consideration. You can keep this.
Can it be on 11th, 10th, I have some 11th, huh?
11th, no problem. 11th, fine. Saturday,
Oh, 11th.
13th, fine.
13.
13th.
And diploma.
Yes, sir. What can we do for you? Upendas.
Yes, my lord, that I admit. My lord, only one thing is there, my lord. On last 4/1/2024, this court directed to file affidavit, my lord. This could not be filed as because she could not procure the pay slip certificate, my lord.
We will say Upendas from the date the judgment of Upendas was applied for others.
Yes.
From that day, you will be also extended the same benefit, minimum scale of pay, and the areas thereof will be clear to you.
My lord.
And whatever other conditions are there in Upendas, that will squarely apply to you.
My lord.
Yes, Mr. Dere. That will do?
Yes.
Phil.
Another, just I want to.
No, please, what it is?
Bring to your notice, your lordship, that Annexure D, my lord, page 27, my lord. In that letter, my lord, director, that is the respondent number 6, my lord, of planetarium, informed that she is working since 1994, my lord. But in the next page, my lord, that is Annexure E, my lord. Here, my lord, that director informed that she is working since 1993. Yeah, that is the difference, contradictory.
We will not go into all those things. We will say that your case, you have made this application on 2 grounds: for the minimum scale of pay, or the minimum pay that was given to this category of people that was denied to you. That has to be released. And now that decision and your regularization, which cannot be considered in view of Upenda's.
Right.
So the Upenda's decision from which date the government had applied for others similarly situated persons, they will apply to you.
Right.
The provisions thereof, including that of minimum pay scale, will be authorized to you.
Right.
We will give a time frame, 3 months, 4 months, whatever it is, within which they will have to
Right.
consider
Right.
and pass.
Right.
That will do.
Right.
And if you are to receive any money for a period prior to the application of Upendas,
Right.
you are at liberty to make an application, representation before the authorities claiming that amount, which also they will consider and dispose within a period of 1 month or 2 months, whatever it is.
Right.
That will do.
There is no pendency there.
Not pendency. So we'll go with Upendas also.
Sitting minor.
Disposal. We'll get the order.
Minor.
How would you do? Mr. Monto,
My lord.
your challenge is manual assistant.
Yes.
Respond number 5 and respond number 6. Nothing beyond that.
Nothing yet.
Whatever has happened with the other posts, we are least bothered. We are only concerned with respond number 5 and respond number 6. With respond number, just trying to understand. If that is so, we need not delay the hearing. With respond number 5, your only allegation is that he was working for a long time. So his date of birth cannot be 1184. And with regard to respond number 6, reasonable bias, reasonable likelihood of bias. So that is the query. With regard to respond number 5, is there any material available on record which would demonstrate that his date of birth is not 1184, but 1771?
But they, as per their affidavit, they are saying that on the basis of the document relied by the respondent number 5, showing the his date of birth was 84, they have accepted. So, well, they are the best person to produce that record.
Why should you have made raised
I have
no, you
access.
have raised a grievance against this person.
It is I acquired from the my lord
If that's the only allegation against that man.
some source, my lord. So that is my allegation. But
So-
they have to prove these things.
No. Why should he? He says this is my matriculation certificate.
But the
84.
But the certificate they are relying, that is thing, my lord, verified by the court.
Why should that is for their headache? You show something.
No, nothing, Nemali. I
Then
fairly submitted, but I
respond
have
number
nothing to
5
show.
gone.
Only that.
Only thing is respond number 6.
Yes, my lord.
You make your submission. So
Well, this is my lord, the very, I'm from very beginning, my lord, I was taking this stand. That he being a son of the one of the member, and not to that, but he's a registrar of the son of the registrar of the maternity department. My lord. So being that in position, so he is a part of the entire selection process. So every possibility that he has some
what were the components of the selection process?
component, my lord, that was written then followed by the my lord.
So show me something here which will demonstrate that the written examination was also conducted under the control of the registrar.
My lord, kindly see, my lord, their
Or your pleadings to that effect.
my lord, their my lord,
No, your pleadings first.
of my pleadings, my lord. My lord, para 8.
Yes. In charge of the selection process.
My lord, the humble petitioner, my lord, beg to state that respondent number 6 is the son of the respondent number 3, who is a registrar of the office of the Controller of Legal Metrology, Assam, under whose authority the call letter for the interview of the post of the manual assistants and the other posts were issued, as well as he was one of the member of the interview board constituted for the purpose of the interview of the candidates for the post of the manual assistant, laboratory assistant, attendants, and the peon cum chokidar peon chokidar cum peon in the Department of Legal Metrology, Assam. The respondent number 3, by dint of the capacity of the member of the interview board, personally interviewed his son, the respondent number 6, for the post of the manual assistants and managed to got the selection and the place
in the serial number 9 of the merit list for the post of the manual assistant in the Department of the Legal Metrology, Assam, it is palpably clear that the taking the advantage of the being the son of the respondent number 3, the respondent number 6 has been really selected and placed in the merit list of the serial number 9 among this total number of 20 candidates for the post of the manual assistant in the Department of Legal Metrology, Assam, depriving the petitioner who has did her best in the interview has the selection of the respondent number 6 for the post of the manual assistant as well as entire list of 20 candidates selected for the post of the manual assistants in the Department of the Legal Metrology, Assam, held on 24/1/2014 is absolutely illegal and liable to be set as a class.
We got it.
So to that effect, they have filed the affidavit.
They have filed the affidavit and their statements are only to the effect of his participation in the interview process. Other process they have not touched.
But they are not saying that he was not part of the entire election process, my lord.
That is evident from the call letters and everything.
Yeah, everything. And moreover, my lord.
So biasness.
Moreover, another point also there, my lord. There, my lord, stand initially the advertisement saying there is a reservation for women.
I'll come to that.
Yes.
I'll come to that.
Okay, my lord.
Let's get over with 6.
My lord.
So he being a man who is controlling the whole show, so a reasonable likelihood of bias arises. What is your decision on that?
My lord, this is, my lord, the decision.
Ashok Kumar Sharma.
Ashok Kumar Sharma, before that, my lord, I want to rely my lord, the Javed Masood, my lord.
Javed Masood.
My lord,
Javed Masood is again a case pertaining to PSC.
My lord, here it is, one thing is very clear, that in the entire selection process, though that was challenged, the father of the candidate, he withdrawn from the selection from the initial. So he said that my daughter is there, so I am not able to.
Javed Masood has been considered in Ashok Sharma.
Yes, Ashok Sharma, and that is also on the basis of the Nagras, my lord.
For you it would be Ashok Sharma,
yes,
which would be in that sense.
Yes, my lord. So here, my lord, but in my case, that was not there.
We have a copy of Javed Masood.
Yes, my lord. Javed Masood, my lord, Nagras
84-2.
Yes, sir. That is the last but one para, it is specifically mentioned, my lord. Javed Masood. Sorry, my lord, certain marks are there, my lord.
No, it's okay, it's better. This here, the father had disassociated himself when his daughter had appeared. He was the principal of the medical college.
He was the principal, but quorum was not, my lord, there. Quorum was there because the quorum saying the chairman and the one of the members. So 2 members were there from the 2 medical colleges. He is one of the medical college principal. He withdrawn because his daughter was appearing in this selection process, my lord. So there was court hold that there is no possibility of any biasness because he was not able to know about the marks of the candidate.
What is more important herein is he disassociated himself from the stage of written examination.
Written examination as well as the interview also, entire process, my lord.
No, he disassociated himself from word go.
From the very beginning.
That is why the bias, allegation of bias was not accepted by the court.
Yes, my lord. But here, my lord, the selection process, although there was there, but may not be well written or by the other way, but this selection process is there. So
no, there is a question. Was there a written examination?
But from this record, it is not showing that the written examination was they are not able to show on that day also the department whether any written examination over there.
So we'll go by that. It was only an interview.
Yes, my lord.
Okay. Next, Ashok Kumar Sharma.
Yes, my lord. Ashok Kumar Sharma also same allegation.
Para 16 and 18.
Yes, my lord. The 2 of the selected candidates were related to the members of the selection committee.
You can refer to para 16, more particularly para 18.
Yes, my lord.
Tripath was followed. And herein the differentiation was made by a selection considering a normal selection committee.
Yes.
And the PSC.
PSC.
PSC, it said you will have to only move away.
Yes.
But in a normal selection process, it said you cannot be there. You should not participate.
Yes, madam.
Anything more?
No, to that I expect, madam, this is only 2 judgment. And the other department it was.
I'm coming. Yes. I'm coming. Women reservation admittedly not given. Women reservation is post-wise.
Yes, ma'am.
And they having held selection for 3 different category, they ought to have given for each one of them. In the reply affidavit they have filed, they said, well, this is not given in the advertisement, so we have not provided.
Yes, sir.
But in the RTI application that you have brought on record, they have said that, see,
5
we have
posts.
given 5 posts for that lady.
Yes.
And only plea that they have taken, you countering you,
Yes, sir.
is that you in your writ petition says I was the only lady. They say, I think around 22 other ladies were
Ladies are
there.
there.
So that's a different context.
But the other posts are there, but they're not only the material, but it's a peon and other Sokidar and peon posts also there. But they are not saying that in the department, in the post of the manual
They have not answered that.
manual
it is not-
assistant, they are not a single woman was
They
there.
say it's a field level post.
Yes, ma'am.
So, and a presumption is drawn
Yes,
that
ma'am.
this lady cannot walk.
And
But
more-
if you see the Women Reservation Act of ours,
yes, ma'am.
of our state, you cannot on your own say we will give women reservation or we will not give in women. If you don't want to give, you will have to take an exemption.
Yes, my lord, the Nilim Das, my lord, very clear, my lord. It is Honorable Justice, my lord, Ujjwal, we are say giving this as well. And moreover, my lord, very interesting thing, my lord, the one parawise comment, my lord, that was also there, where they are specifically mentioned that being I am a woman, and as the my lord, work criteria is required some sort of works, which is I beyond
That they cannot, because if
That
they
is
have
in
to, they will
parawise
have to take
comment.
an exemption.
parawise comment is very, very there, my lord.
Parawise will not. They have an affidavit.
Yes, my lord.
So this is the case.
Yes, my lord, this is my case.
Yes, Mr. Goswami or Mr. Chhetri. You can decide. We are not touching respond number 5.
Yes.
Nothing, no material. Respond number 6. Now you satisfy me. Why should we
My lord, here in para.
facilitate
Yes.
the father to make the second son also get
Yes.
himself appointed?
Yes, yes.
One got appointed, fine.
My lord, he has relied on the para 8. Para 8, he has stated the respondent number.
Mr. Chhetri, forget what he has stated. You are the son.
Yes,
You are the father was the registrar.
yes.
Show me that he was not involved in the selection process at
Yes.
any stage.
He was not in the, he was not involved in the selection. That part, my lord.
Then
Already
why did he proceed to issue this call letters and all?
all letters, my lord, selection, my lord, on the, my lord, here. Firstly, I will rely on the documents, my lord. That is, firstly, my lord, as per this advertisement, 14/11/2023, my lord, that he has participated in the selection.
Who?
See,
Hmm.
participated in the selection. And if anything is wrong, was wrong,
There's
my
nothing
lord,
wrong here.
that part, my lord, he has to immediately file his, he has to file the objection, man, or complaint.
What is
before
the
authority
mistake?
concerned.
Mr. Chhetri, what is the mistake here? Everything is correct here.
My lord, that is the law decided by this honorable apex court, saying that once a person is participated, he cannot come back and say that selection is bad in law.
Mr. Chhetri, there is a case of our High Court
Yes.
wherein this court division bench held that because the advertisement condition was not challenged, women reservation will not come in.
Yeah.
That
Yes.
matter traveled to the division, Supreme Court. Supreme Court reversed that order.
That's true.
It's
but-
automatic application.
Yes. And my lord, since in
You
the,
forget women reservation for the
yes,
time being.
yes, yes.
Let's concentrate
Now,
on
now, my lord,
the activities of respond
as per
number
the
3 and
selection
6.
committee minutes, my lord, that is 21/2014, my lord. In the affidavit filed by the government, my lord.
I've seen it. Clause
My lord,
number
here,
5.
yes, minutes is very specific, my lord, and as per this minutes, my lord, that if anybody's son or daughter is there, then the member will be abstained from the
At
said
that
in-
time. At that time.
on the day of his son or
Now, show me, just to show me that, show me something on record that without the respondent number 3 being a part of the selection
Yes,
committee,
that part, my
the
lord,
quorum will not be fulfilled.
yes, that part, my lord, we have filed an affidavit, my lord, to that extent, my lord.
That without the respondent number 3 being in the fray, the
Yes.
selection cannot be held.
Yes,
It will be violative of some law. There is a.
my lord, our affidavit in opposition, lordship.
Respondent number 6.
Yes.
Yes. Your statement is at page 62, internal page 2, para 6.
Question number 6, my lord.
You will have to show because the Supreme Court decisions in Ashok Sharma is against you. Para 18 is against you.
Yes. My lord, here in the Ashok Sharma case, my lord, there, which the Rasul case has been,
Javed Rasul is in a different fact situation.
my lord, here in Javed Rasul case also, it has been decided, my lord, the persons who were the member of the board, my lord, he was present on the day of selection, my lord. And
Rather, it's the other way around.
yes,
The father principal, he abstained from word go. And I'm not participating because my
My
daughter
lord,
is participating.
whatever I have found,
Okay.
my lord, just I'm reading that extent. My lord.
Mm.
I will read out that part of it. My lord, here in para 6 of my affidavit, my lord.
We have read that. What do you have to submit on that?
Para 6, with regard to the statement made in paragraph 8 of the writ petition, the deponent denies the same. My lord, he said that his father was present on that particular day.
That we are not
It
accepting.
is strong, my lord. Next is that though the father of the respondent number 6, Sri Hemendra Taran, was a member of the selection committee, but at the time of interview of his son, that is respondent number 6, on 27/1/2014, Sri Hemendra Taran, the said member was absent in the selection board. So he was not a judge of his own son, my lord. The deponent further expressed that he was selected in the interview as per his merit on the reserved vacancy of STP, my lord. He is not the general category, STP candidate, my lord, STH. But the petitioner does not belong to STH candidate. She is a general candidate, my lord. And it was specifically mentioned in column 5 of the selection committee meeting held on 21/2014 that if any son, daughter, or nearest family member of any member of the selection board appears for interview and vice versa, the member of selection board shall abstain from the interview, which had been followed accordingly. Well, this selection committee minutes, my lord, it has not been challenged before this honorable court in the.
What is there to be challenged there? Nothing.
It has not been challenged, my lord.
What is there to be challenged, Mr.?
My lord, since as per the selection board committee, this minutes of the meeting, my lord, this father of the respondent number 6 was abstained on the day of interview, my lord. And that is done as per the minutes of the selection committee, my lord. That has been done in all cases, my lord, not only in my cases, in other cases also it has been done as per the selection committee's minutes of the meeting, my lord.
So you are relying on Javed Rasul?
Yes. Javed Rasul, here, my lord, since he has relied on the Javed Rasul, my lord, para 13 and 14, my lord. It is his judgment, my lord, since it will be helpful for me, my lord. 13, my lord, we finally married, lord. We finally come to the submission on which Sri Anil Dev Singh laid considerable emphasis, namely that the entire selection was vitiated by the presence of the selection committee of the father of one of the candidates. This was said to be a gross violation of one of the principles of natural justice. The grievances is not real. The principal of Medical College Srinagar, whose daughter was a candidate for admission to the medical college, informed the selection committee at the very outset about his fact and told them that he would not have anything to do with the written test and would not be present when his daughter was interviewed. The other members of the selection committee accepted the suggestion of the principal and did not think it necessary to address the government to appoint a substitute member of the selection committee, since government had fixed the quorum for a meeting of the selection committee as the chairman and one and other member, and it
Now
was
read carefully. Now that words read carefully.
yeah.
And onwards, read carefully. Word and onwards, kindly read carefully. And
Well,
it was
I'm reading.
possible.
But selection, since the government had fixed the quorum for a meeting of the selection committee as the chairman and one other member, and it was possible to have a quorum without the principal of the medical college, Srinagar. The procedure
No,
adopted
no,
by
no,
the
you have read it wrong. And it was possible, to have a quorum without the principal of the medical college.
My lord, I may be allowed to.
Hmm.
The procedure adopted by the selection committee and the member concerned was in accord with the quite well-known and generally accepted procedure adopted by the public service commissions everywhere. It is not unusual for candidates related to members of the service commission or other selection committee to seek employment. Whenever such a situation arises, the practice generally is for the member concerned to excuse himself when the particular candidate is interviewed. We noticed that such a situation had also been noticed by this court in the case of Nagarjun versus State of Mysore, where it was pointed out in the absence of mala fides, it would not be right to set aside the selection merely because one of the candidates happened to be related to a member of the selection committee who had abstained from participating in the interview of that candidate. Nothing unusual was done by the present selection committee. The girl's father was not present when she was interviewed. She was one among several hundred candidates. The marks obtained by her in the written test were not even known when she was interviewed. And in fact, we find that as a result of her performance at the interview, she lost rather than gained some places. 14, my lord. Great reliance was placed by the learned council on A.K. Tripak, which was relied on Ashok Kumar Yadav case, my lord, in para 18, lordship. On the question of natural justice, we do not think that the case is of any assistant to the petitioners. It was a case where one of the persons who sat as a member of the selection board was himself one of the persons to be considered for selection. He himself sat, my lord, in the selection. He participated in the deliberation of the selection board. When the claims of his rivals were considered, he participated in the decisions relating to the orders of preference and seniority. He participated at every stage in the deliberation of the selection board, and at every stage there was a conflict between his interest and duty. The court had no hesitation in coming to the conclusion that there was a reasonable likelihood of bias, and therefore there was a violation of the principle of natural justice. In the case before us, the principal of the medical college, Srinagar, disassociated himself from the written test, and he did not participate in the proceeding when his daughter was interviewed. When the other candidates were interviewed, he did not know the marks obtained either by the daughter or by any of the candidates. There was no occasion to suspect his bona fide even remotely. There was not even a suspicion of bias, leave alone as reasonable likelihood of bias. There was no violation of principles of natural justice. This is there, my lord. This clear case, my lord, which is covered in my case. And my lord, this Ashok Kumar Yadav, this Ashok Kumar 1985, which he has relied on, my lord, this full bench. My lord, in para 18, para 18, that
straight away come to 1, 2, 3, 4, 5th line.
Yes.
There can be no doubt.
No, this is on the basis of the A.K. Kripak case, my lord. A.K. Kripak case, my lord, has been
just proceed to read.
Yes, my lord, I am reading from the para 18 itself, my lord.
Okay, okay.
We must straightway point out that A.K. Kripak case is a case of landmark in the development of Indian state law, and it has contributed in a large measure of the strengthening of the rule of law in this country. We would not like to whittle down in the slightest measure a vital principle laid down in these decisions, which has nourished the roots of the rule of law and injected injustice and fair play into legality. There can be no doubt that if a selection committee is constituted for the purpose of selecting candidates on merit, and on the members of the selection committee is closely related to a candidate appearing to for the selection, it would not be enough for such member merely to withdraw from participation in the interview of the candidate related to him, but he must withdraw altogether from the entire selection process.
That is the case.
Now, Lordship will come.
Now you go ahead.
Yes. Withdraw altogether from the entire selection process and ask the authorities to nominate another person in place on the selection committee, because otherwise all the selection made would be rejected on account of reasonable likelihood of bias affecting the process of selection. But the situation here is a little different, because the selection of candidate to the Haryana Civil Service Executive and Allied Services is being made out.
No, it is being not made by it.
Lordship. I may be allowed to complete my not by any selection committee constituted for that purpose, but it is being done by the Haryana Public Service Commission, which is a commission set up under Article 316 of the Constitution. It is a commission which consists of a chairman and a specified number of members and is constitutional authority. We do not think that the principle which requires that a member of a selection committee whose close relative is appearing for selection should decline to become a member of the selection committee or withdraw from it, leaving it to the appointing authority to nominate another person in his place, need to be applied in case of constitutional authority like the Public Service Commission, whether central or state. If a member of a Public Service Commission were to withdraw altogether from the selection process on the ground that a close relative of his is appearing for selection, no other person save a member can be substituted in his place, and it may sometimes happen that no other member is available to take the place of such member, and the functioning of Public Service Commission may be affected. When two or more members of the Public Service Commissions are holding a viva voce examination, they are functioning not as individuals but as a Public Service Commission. Of course, we must make it clear that when a close relative of the member of a Public Service Commission is appearing for interview, such member must withdraw from participation in the interview of that candidate and must not take part in any discussion in regard to the merits of the candidate. And even the marks or credits given to that candidate should not be disclosed to him. So-and-so Chinnappa Reddy, so-and-so, so-and-so. Now this para 30, the next sub-para, the procedure adopted by the selection.
You have already read. That is with regard to Javed Rasul. Come just below that.
Javed Rasul.
Javed Rasul has been upheld here.
Yes.
You can come to the paragraph next. We wholly.
The procedure.
We wholly. The next paragraph. We wholly endorse those observations. This is quoting of Javed Rasul.
Yes. That is why this Javed Rasul. Let me complete. Otherwise, the procedure adopted by the selection committee and the member of concern was in accord with the quite well-known and generally accepted procedure adopted by the Public Service Commissions. So and so everywhere, it is not unusual or candidate related to members of the Service Commission or other selection committee to seek employment. Whenever such a situation arises, the practice generally is for the member concerned to excuse himself when the particular candidate is interviewed. We notice that such a situation had also been noticed by this court in the case of Nagarjunan versus State of Mysore, where it was pointed out that in the absence of mala fides, it would not be right to set aside the selection merely because one of the candidates happened to be related to a member of the selection committee who had abstained from participating in the interview of that candidate. Nothing unusual was done by the present selection committee. The girl's father was not present when she was interviewed. She was one among several hundred candidates. The marks obtained by her in the written test were not even known when she was interviewed. In the case before us, the principal of the medical college, Srinagar, disassociated himself from the written test and did not participate in the proceeding when his father was interviewed. When the other candidates were interviewed, he did not know the marks obtained either by his daughter or by any of the candidates. There was no occasion to suspect his bona fide even remotely. There was not even a suspicion of bias, leave alone a reasonable likelihood of bias. There was no violation of principles of natural justice. We wholly endorse this observation. Here in the present case, it was common ground between the parties that Sri Raghuvar Dayal Gaur did not participate at all interviewing Tilaknath Sharma, and likewise Sri R.C. Marja did not participate at all when Sakuntala Rani and Balbir Singh came to be interviewed. And in fact, both of them retired from the room when the interviews of the respective relatives were held. Moreover, neither of them took any part of any discussion in regard to the merits of his relatives, nor is there anything to show that the marks or credits obtained by their respective relatives at the interviews were disclosed to them. We are therefore of the view that there was no infirmity attaching to the selection made by the Haryana Public Service Commission on the ground that though their close relatives were appearing for interview, Sri Raghuveer Dayal Gaur and Sri R.C. Maria did not withdraw completely from the entire selection process. This ground, as on behalf of the petitioner, must therefore be rejected. So this is the so, my lord, here, apart from all these documents, this citation relied by him, my lord, that part since it will helpful for me, my lord. And that apart, my lord, in para 8, here's specific allegation against me that my father personally participated and
That has been denied.
That has been straightway denied. He was not there. And that government record will also support, my lord, that he was totally absent on that particular day. And this was done not by my wish.
Particular day means he was not participating in the selection process at all.
No, my lord, on that day, my lord, as per these minutes of the selection
on
committee,
that day, other than him, there will be other candidates who have been interviewed.
my lord, in other candidates, my lord, in other candidates, that day he did not appear. That day, when his son
how many days were the interview held?
Lordship.
How many days the interview was held?
4 or 5 days, my lord, interview.
So for one whole day of that interview,
yes, he did
the
not.
father of the petitioner
No.
did not participate.
No.
Can it be demonstrated from the records?
Yeah, it may be. It may be.
And what do you say about the allegation?
My lord, since
Mr.
Lordship.
Chatri, what do you say about the allegation that you were one of the persons who were involved in the initial, from the date of advertisement, from the issuance of advertisement, call letters, everything, you were the master?
No, call letters, my lord, regarding giving call letters and this selection, this interview, all these things, my lord. When there is a minutes of the selection committee meeting, selection committee, my lord.
Who constituted that selection committee?
The government, my lord.
Government
Government
and
constituted
under
the
some law,
Lordship.
under some act
That-
or rules.
That government knows, my lord.
Okay.
Because
Thirdly,
on the basis of this.
thirdly, if your father was not there, was it easy to your case that if your father does not participate in the selection process, the selection process, like in Javed Rasul's case, cannot be taken forward?
Cannot be taken because there is a specific, my lord, lordship is very much
No,
aware.
I'm saying that you disassociated yourself from when he appeared, fine. No objection, no question on that. But I'm asking a further question that if you were not there in that selection process at all, because one of the allegation against your father is that in an earlier round of litigation, he got his one son. Now in this other son, it may be material, it may not be material. But the question is, if you were not there in that selection committee, whether that selection could not have been taken forward.
No, since with regard to the another son, my lord, that is not the subject matter in the case.
I'm just taking note of
No.
the allegations leveled
But,
against him for malafides.
suppose, my lord, today I'm there, my lord. If my son gets the and perform the good interview or good result, my lord, as because my son, I'm the boss of the particular office, doesn't mean that I will support him or all these things, my lord. Because of his own merit, he might have got it. All the time, my lord, we cannot suspect that as because his father was there, so he has been
Overboard.
yes. We cannot
Yes,
suspect.
Mr. Goswami. Women reservation, you have nothing to say. It's for them to say.
Yes, my lord, women reservation, since this already as per this advertisement, the picture is very clear, my lord. Women reservation, my lord, whatever they have given, my lord, 5 posts for women, my lord. They have given.
They
as
have
per
not mentioned.
advertisement.
No, they have not mentioned in the advertisement.
No, the reservation.
Advertisement, there is no mention that women will be 5.
My lord, since lordship.
Just check up the advertisement.
Yes.
Correct me if I'm wrong.
My lord, once again, we are reading. my lord.
Read it.
Yes.
Satisfy yourself.
Page 26 of the
Hmm.
decision.
Yes, Mr. Monto, is there any reference to women reservation here?
Yes, my lord. In advertisement, my lord, annexure 1, page
Application-
56, it is lordship
No,
will
no,
come
for a
to.
post of manual assistant.
No, it is there, my lord, only saying the
No.
first row, column, my lord, first, 1, 2nd, 3rd, 4th, 5th, my lord.
Hmm.
No, 6
They've
column,
got it. Women,
Women.
MOBC, women 2.
women too.
Yeah.
But subsequently, they have advertised the all 3 posts. First is a manual, second is in laboratory assistant, and third is in peon cum executive.
Hmm.
So where they have not specifically mentioned, but they are, in general, they are showing it is women. But interestingly, in the first affidavit, they are saying there was no such type of women reservation, but in RTI, they are saying that as per the
5.
complying the provisions, we have appointed 5 numbers of complying this women reservation.
No, no, yeah, lordship, can I just,
Yes, Mr.
the remarks, my lord.
Hmm.
My lord, in the advertisement, my lord, application are inverted, so and so, so and so. My lord, manual assistant, total 20 posts, my lord. Requisite qualification 20. And my lord, reservation, my lord.
Mr. Chetri, have you gone through the Act? Women Reservation Act
2005.
5. If you come to section 5 thereof, if you want to exempt any office or any establishment from the purview of the Act, special exemption has to be taken from the government.
That part, my lord, they will answer, my lord.
That let them, we'll talk to them.
They will
We'll
answer.
leave it
My
with
lord, only I would like to appraise your lordships, my lord, regarding remark column, my lord.
them.
In the district and subdivisional level office, throughout the state duties in the post is field work. The candidate should capable to work in the remote areas, also stay overnight. That is why, my lord, for manual assistant, the reservation has not been given for women, my lord, because they have to stay overnight. Sometimes there is a
Police.
manual assistant is a very toughest job, my lord. Any area, remote area, he has to stay. That is why, considering that aspect for their safety, my lord, that measure has been taken by the government, my lord. And in the case of laboratory attendant and peon chowkidar, my lord, this totally 5 posts for women have been reserved by the government by giving the advertisement, my lord, this.
Okay.
And here, my lord, in the remarks, each for Office of the Control of Legal Metrology Assam and Office of the Assistant Controller of Legal Metrology Gujarat duties office work, and in the district and subdivision level office.
I got it, Mr.
Yes, yes.
I got your point.
Yes,
You mean to say because of the nature of the job?
yes, yes,
They have not.
yes. And
Yes, Mr. Goswami. Anything more, Mr. Chetri? Anything more? Anything more?
yes, my lord, I would like to rely on some of the judgment, my lord.
Yes, that most will. You can give me the citations.
Lordship. Lordship, Tasbir Singh Sodhi, my lord,
Hmm.
and others versus State of Jammu and Kashmir
Hmm.
and others. My lord,
Reported in.
that is Manupatra, my lord, oblique SC, oblique 0314, oblique 2023, my lord.
You will have to give me a copy.
Lordship.
Para?
Para, my lord, from 12 to 12.3, 4 and 12.1.
For the
The-
proposition?
And my lord, this is my lord, once the persons appeared in the selection, participated in the selection.
Madanlal.
Yes.
Okay.
The another my lord, this sorry, 7,000.
But we have a decision in Sadananda Haloi also,
Yes. That, yes,
watering it down a bit,
division bench.
creating a new
My lord,
space. I think it's a judgment by my Lord Justice Gogoi.
now lordship, another judgment, my lord. A judgment get a ulvasan. I will supply all these judgments.
Just make a mention.
Yes, lordship. Union Public Service Commission versus
Hmm.
M. Satya Priya
Hmm.
and others.
Satya Priya.
Yes.
Hmm.
And Satya Priya.
Hmm.
2018, 15 SCC,
Hmm.
796, para 17 months. This is para 17. Just I'm just reading my one. The selection committee consists of experts.
Hmm.
A lot of
Yes,
people
yes,
understand. Just I'm
Please do so.
the para 17 Lord.
Hmm.
The selection committee consists of experts in the field.
Hmm.
It is presided over by the chairman or a member of UPSC and is duly represented by the officers of the central government and the state government who have expertise in the matter. In our considered opinion, when a high-level committee or an expert body has considered the merit of each of the candidates, assess the grading and considered their cases for promotion, it is not open to CAT and the High Court to sit over the assessment made by
Got
the
it.
selection committee as an
Got it, Mr. Proti. Got it.
Gotcha.
Anything more?
Then, my lord, another Sangita Chankham, my lord, and others versus
Citation?
2000 Manupatra, my lord, Manupatra oblique MN.
You can just ask your colleague to just give a small paper
I will
with
supply
the citation and the copies
I will supply the judgment.
and the paragraphs.
Yes.
But these are on the proposition that after participation, you cannot. Satya Priya following Javed Rasul. That's it. Anything more?
Yes. But if it is so much, then I will supply all this judgment, whatever.
Please
it
do
is.
so.
So it will be easier for lords.
I want it.
Yes.
Give me. Give me the paragraphs also.
Yes.
Yes, Mr. Goswami. You have the records with you?
Yes, Lordship. Lordship, regarding the retaliate to the father, whether the father was appeared in the selection process or not. On that regard, Lordship, I would like to submit the selection committee meeting dated 20/01/2014.
We have got it.
Yes, Lordship. It is categorically stated that he will not appear during the.
Now tell me one thing, Mr. Goswami, before we proceed. Who constituted this selection committee?
Yes, Lordship.
And Mr. Goswami, you are relying on that selection committee minutes.
Lordship.
See how what is this position of the respondent number 3 there in Lordship?
Uh,
He is the member secretary.
yes, Lordship.
He is the main man.
Lordship.
Anything more is required to be added?
Lordship. But Lordship, so far from the record, Lordship, I would like to
Kindly,
submit
kindly. That's the only way you can now.
531 from 517 to 542, Lordship. He was not appeared during that process of selection, Lordship, where the respondent 6 was appeared, Lordship.
Let's see.
These 25 candidates, he restrained him from the selection process, Lordship.
What was the total marks?
Lordship, it is 50, Lordship.
There was no written examination.
Lordship.
Huh?
Lordship, no written.
5, 20, 40, 50 marks. 50 marks.
Yes.
So he
Total
is
50.
Teron.
Yes.
Mm,
Around 550.
Serial number?
531. 531. This is the
Obvious Teron, but there is no marking here.
look, because his father. This is the marks which is given to the member secretary, Lordship.
Show me the other marks of Mr. Teron.
Yes. No.
Who had marked Mr.
Yes,
Teron?
Lordship,
How many?
Lordship.
There were 1,
I-
2, 3, 4, 5 people.
Report is there? Other members given the marks 530. 530. 531, Lordship, the one M. Rasbongsi, the member secretary, Lordship, he given.
He is not a member secretary. He is a member.
Member, sorry, Lordship, member. He gave him 32 marks total out of 50.
To the
This one, respondent 6.
6. Just show me that.
Yes. No? It took 22. Another Lordship member selection committee, J. Borua, Lordship.
We are only concerned with Amaresh Sharma and respondent number 6 here. Right?
Yes, Lordship.
When is the number?
He gave 30 marks.
Amaresh Sharma, this is
It will detail.
54.
देखे हम लोग एक बार। This is- yes, this is the-
Okay.
Yes, it will detail. Very nice. Five 30. Second level.
Where is the consolidated mark sheet?
Yes, Lordship, this one. Statement, Lordship, comparative.
This is the consolidated.
Yes, Lordship.
Okay.
Respondent 6 got 22, average 22. 22%. 22%.
And this is serial number, respondent number 6 is serial number
6,
346.
531. 531.
Okay. Okay. Amaresh Sharma is an
44,
ST,
44.
is a general category.
Yes, Lord, sir.
Anybody scoring more marks than Amaresh Sharma?
I don't know.
Find that out for me.
Lord, sir. I will.
Okay, we'll just take that trouble of going through.
Lord, sir.
30.2 or so. Litondas.
Lord, sir.
Litondas.
Almost so much looking heavy to heavy, so-
Because there is another issue here. Whether how many posts were there for general, Mr.
Yes. 30.
How many posts were reserved for open for general, open category?
It is 16 lordship, 16 lordship in manual assistant lordship.
16 posts.
Yes, lordship. Amaresh Sharma within 16 lordship.
Hmm.
His mark is within 16.
And this. So, Amaresh is within 16.
Yes.
Then how come the respondent number 6 was appointed as a reserve category candidate?
There
He
are
was
ST
STH
Hills is there.
candidate.
Yes, ST Hills is there.
He may be an STH,
That's
but how can he be appointed as STH when he has scored so much marks? 30.25, more than Amaresh Sharma.
Yes, he cannot eat up.
He cannot interfere. Now prepare a list
Lots.
of persons
Lots.
who have got that much
Lots.
from this.
Lots. Selected person.
Mr. I was a bit, after Mr. Chetri made that argument that he is an STH, that somehow missed when I was reading. And when Mr. Chetri made that argument, I was pondering, now how will the petitioner come in? So she'll not come in. But now if Amaresh Sharma has got 29.2 and appointed, then he having got 30.5, he'll be over Amaresh Sharma. That means he has also come in as a general category candidate. So if we interfere also, he'll come in. Make that 2 o'clock, we'll take it up.
Lots.
We are finishing it today, Mr.
And moreover, my lord, one thing, my lord,
Hmm.
they are relying the minute, that is actually not the minute, my lord.
Hmm.
Because that is prior to the interview. It is on 21/2014, but interview was held from 24/1/14, my lord.
Mhm.
So this is
24?
not cannot. This
24 January,
Yes, my lord.
after this minutes,
After that, but this is not a minute, my lord. So minute is the entire process of the interview, my lord. That's what will be reflected on that. This is prior to the minute the interview. There's some proposal has been taken.
I'm not relying upon any minor lordship.
Yeah,
Election
anything
committee
they say.
Mr. Goswami is trying to project that, see, we have a resolve to hold this election in a particular manner.
Yes, my lord.
That much only.
But they,
Technique ready, would it?
I mean, for the lesser,
Mr. Goswami, just have somebody to work on it.
Lordship.
Can you give me that list by 2 o'clock or 2:30? 2:30 also.
It means the highest.
Just find out first 16 persons from that list.
Lordship.
That much will do.
mass objection.
Because we have noticed 30.25. Just make a mark.
And there are total 5 members, but whether marks was given by 5 or 4, my lord. This is also important.
And Samiksha Monta is at which serial number? Mr. Monta's client is at which serial number?
Serial number.
Roll number was A.
That is rule number is the.
Roll number, my lord. MA 241.
No, serial number.
MA 241.
Hmm?
Rule number MA 241.
Page number
MA 241.
Yes, my lord.
Comparative statement, page number 16, so, the name of the Sarmista Mahanta is there. The petitioner's name
Page
is
number
there.
16.
Page number 16, Lordship. Comparative statement, the statement of the candidate.
Oh. Very low marks. Not even 20.
But I think that she is more qualified than the category selected, my lord.
No, that's a different thing.
She was a student of
And
BA.
also, Mr. Goswami,
But otherwise, I'll come
I'll
on the
require
quota.
one more thing. You said that you made a submission. There is a contention in the affidavit that 22 or 29 ladies, females have appeared. So I just want to know whether the position of Samiksha Mohanto amongst those ladies. These two instructions.
Mas-
And Mr. Chetri, 4 members in 5 out of 4 only interviewed you, but you got 30. Highest. Very meritorious. Very meritorious.
Category, madam, category wise. The marking is category wise.
Whatever category it is there,
Yes.
Paresh Sharma and you consistently good marks.
No, only.
Nothing, it doesn't mean anything. It doesn't mean anything, but it indicates something.
I do not know, my lord, since the marks have been given.
Because
by
your contention in the affidavit is that you have been appointed as a STH candidate. How can you be appointed as an STH candidate when you have got so high marks? More than Amaresh Sharma. You will be a general category candidate.
No, maybe.
It's a different question whether Mr. Mohanto's client gets it or not. But this selection in this manner, at least tentative view, cannot be subject to what Mr. Goswami can show.
Let us here only on the basis of this, what I have found in the record, whatever the documents I have found, my lord. That was done as per the this selection committee's members, and that, my lord, since they have done it on the basis of what their performance was there. So, my lord, I do not know whether
That is why in the Ashok Kumar Yadav's case,
Yes. That is very much.
that proposition was
Not
brought
the
in.
end.
Your son, the other employees would be your uncles.
no.
Every person,
My lord,
they are also
here-
going to bias.
No, my lord, that all those Rasul case or Ashok Kumar case, my lord, in this case, my lord, the person himself appeared, participated
I
in the
got-
selection
I got-
committee. The person, and he is even given.
We'll
a-
have it, Mr. Goswami, can you just ask somebody to make that for me?
Yes, Lordship.
We'll have it at, if possible, 2, I have fixed the matter after that.
Lordship.
Mas-
My lord,
Tony,
May
Yes.
please, Your Lordship. This is basically a dispute regarding.
Mr. Roy is there.
Yes,
Now you clarify one aspect.
yes, Lordship.
Where these deductions being made? 12% deduction was being made. PPF,
Yes,
but 8.33 was not being apportioned to the pension fund
yes.
because cases were filed before this court.
Supreme Court had given a stay order and yes,
No, this court, was there a stay order?
High Court, this matter.
Not this matter.
Yes,
The deduction.
earlier the matter came to the High Court.
Hmm.
There was a stay order. Since matters were filed in all over the states,
It
it
went to
ultimately
the
went to the
Supreme
Supreme Court, and the Supreme Court had also kept a stay order till 11/11/2003.
Now, after that, what was the percentage of recovery being made from the employee? 12%? 3.6%?
It will
8.33.
be 8.33 itself.
Uh.
Now, the stand of the company herein is that after that Supreme Court had validated the scheme, all the employees who were in the roles of the company at that point of time, this amount was deposited by the company against the EPS scheme, and it was
From where did the company get that money?
from the employees' contributions.
Okay, 95 to 2002.
2003.
Three. So this period, you were not taking any contribution from
No.
the
No,
employees
because the stay order was there.
because of the stay order?
Yes,
So the normal PF contributions were being taken
Yes, yes.
by the company
correct.
and your contribution was being given and deposit being made.
Yes,
Pension fund, no deposit made.
no deposit. The stay-
I want to understand this.
Yes, Lord.
So 95 to 2003, once the Supreme Court decision came and the notifications of the authority how to go about.
Yes.
You deducted amounts with of the employees in office
The existing
from 95 to 2003.
95 to 2003.
You
it was-
made deductions.
Yes, as per the stand in the affidavit, I don't have the records with me, what I was coming to.
Hmm.
The records are not with me, but the stand is there in the affidavit that regarding all the employees, there was no dispute because the company had deducted that money.
No, no,
and there was no dispute.
I'm trying to understand again. I'm
Yes.
asking you
Yes,
whether this deduction from 95 to 2003 was made on a date after the Supreme Court
yes,
total.
yes, total, yes,
Show that.
yes. The statement at from paragraph 4. Paragraph 4, read that. That the petitioner company, page 5. That the petitioner company begs to state that the EPS 1995 was not implemented immediately from 16/11/95 in the petitioner's company due to the fact that there were stay orders passed by the Honorable High Court on operations of this. Subsequently, the matter was transferred to the Supreme Court for final disposal. The Honorable Apex Court validated the scheme. Afterwards, in compliance with the judgment of the Supreme Court, dated 11/11/2003, received from the EPFO Tinsukia, BVFCL had deposited the unpaid pension contribution along with interest for different period in respect of all the existing employees, i.e. as on November 2003 to the EPFO Tinsukia in 2004 towards implementation of the EP.
This is what I'm asking.
Yes.
Whether this amount that you have now deposited was so, because 95 onwards, you're not making a deposit.
Yes.
You deducted all those people's salaries to that amount.
Yes, that is.
And then deposited. You have
Yes.
not said that.
That is again there.
You have not said that. I just want that clarity.
Yes, that is there. Just
Yes, Mr. Roy.
My lord,
This has to be done by the employee, to
No.
the employer, to you.
no,
Your affidavit, there is something else which has been projected.
our affidavit is based on the scheme. My lord,
No, tell me, I don't
my
understand.
lord, I'll tell you, lordship.
You just
The
tell
90
me, don't
what is the-
open any books. You tell
My
me,
lord, 1995,
this amount will come from where?
they will have to make deposit, my lord.
Who? From where will they make? From their own pocket or from
Yes.
deducting
No,
from
no,
the?
my lord, it's like this.
section.
You find out.
Yes.
My lord, it's like this. Prior to 1995,
From 95, let us see what is happening.
All right, my lord. The contribution they have to make, my lord, 12% and 12%, both matching.
24%.
matching. After 1995, the employee's contribution of 12% would be deposited to the PF. From the employer's 12%, 3.667%,
Go to PF.
no, 8.33 go to PF. And the balance amount, 8.33 would go to pension fund.
8.33 pension.
Would
fund,
go to pension
3.37
fund.
to the
And employees makes no contribution.
That is what I want.
Employees make no contribution.
Yes, Mr. Sharma.
Yes, lordship.
If the employee is not to make any contribution with regard to that 8.33, how can you take this plea?
Section 3 of the scheme
Tell me.
says otherwise. It says employees pension fund, section 3. I'm just reading that portion. A part of the contribution representing 8.33% of the employees' pay shall be remitted by the employer. Yes.
That is it.
I am only a collector of the amount that I'm remitting,
No.
but it has to come from his pay.
What is that? PF, what is that book?
This is the
Provident Fund.
Employees Provident Fund.
Employees Provident Fund Act.
My lord, we have explained that in detail.
That's why the confusion. The contrary view. That's why I was asking this question.
The money has to come from his pay, 8.33 of his pay. Now,
That you are paying,
Yes.
Mr. Show me
Yes.
that
So if it is
before
100
95, you were paying 12%.
Yes.
They were paying 12%. So that amount was being deposited in the PF account. After 95, when this scheme came into place, employees 12% directly to PF.
Hmm.
Out of your contribution of 12%, 3.67 to the pension fund, 8.33 to, no, 3.67 to PF, 8.33 to
Pension,
pension.
pension fund, yes.
Now that is your contribution. Where does the employee come from?
No.
Come
And
to the scheme.
Central government contributes 1.16 on the.
On
on
that.
that. That is a different matter. It is under the scheme.
Where is the scheme? Where is the scheme?
Scheme is 1995 employees.
Employees pension scheme 1995.
This scheme
Employees
is under
pension.
section 6 of the Act.
Just a minute. Employees Provident Fund Scheme,
Employees
1952.
pension scheme. This is the pension
Pension
scheme.
scheme. Yeah, that's a minute.
If it is 2018,
My
where
lord,
then
we have quoted the
22.
relevant scheme, relevant portion of the scheme in.
I want the whole scheme.
yes. The employees pension scheme 1995, philosophy will come to section 3.
As amended by Amendment Scheme 2020. Okay, read what is there.
Yes, section 3.
Employees Pension Fund.
Employees, yes, Lordship.
Hmm.
From and out of the contributions payable by the employer in each month under section 6 of the Act, or under the rules of the Provident Fund of the establishment, which is exempted either, this is not relevant, these issues, if a lordship will thereafter come, a part of the contribution starts the line, a part of the contribution.
You read the full one, from and out of
Yes.
the
From
contribution
and out of the
payable by
contributions
the
payable by
employer.
the employer in each month under section 6 of the Act, or under the rules of the Provident Fund of the establishment, which is exempted either under clause A and B of subsection 1 of section 17 of the Act, or whose employees are exempted under their paragraph 27 or paragraph 27A of the Employees Provident Fund, scheme 1952, a part of the contribution representing 8.33%.
This part
of
of the
the-
contribution is a contribution of the
of the
employer.
employee's
To
pay.
the extent of 12% is the pay. Out of that, 8.33% of the employee's pay shall be contribution representing 8.33. Shall be
Yes.
remitted by the employer to the employee's
Shall be
pension
remitted by the
15 days.
employer. Yes.
So,
So it is basically.
so that amount,
Had
whatever
I-
is there, you now pay with the interest as up to date. Let that man.
No, the difficulty, I think the money has already reached him. Because the final order of the authority was, irrespective of these dispute between the employer, the money has to be paid to you within 10 days. I don't have the exact instructions with me right now, but I think it has been already paid.
Get that instruction.
I'll get
If
that.
you have paid it, fine.
But what my understanding is.
CSR. We'll
Yeah.
treat it as CSR.
That is true. But my understanding is, Lordship, had it been 100 rupees of pay to him, of that
This was
8.3
what was troubling me from yesterday when I was going through, because there was a contrary picture given you in your writ petition. When I read the writ petition, I was thinking why the Provident Fund is behind you. Then when I went to their affidavit and I read that, naturally, I've not dealt with much matters in this connection. A doubt arose.
This
Now it
8.33
is
has
clear.
been enjoyed by him as a pay package. He has already taken this money out of, otherwise deducted it from his pay. Had I to have to pay him 100 rupees, I would have deducted.
Is it your
8.33.
case? Is it your case that, see, this 8.33, which I did not deposit in your,
Is already been enjoyed by him in form of a pay.
1 second.
Yes.
How much was the deposit from 95 to 2003 or till his retirement?
That statement is there.
What was your contribution? 12%?
The statement is already there. I have annexed the statement.
Where is that?
Yes.
Whether this component
No,
was already paid.
not in the pension fund, not in the pension.
No, I'm not on the pension fund. Because that 12% under section 6, 12%.
No, I understand, my lordship, whether it is deposited in the PF fund.
PF fund.
That's not there. If that would have been there, that there's no question. my lord.
That is what we have to see now.
Because that's not there. And it is their case also, they have not deposited.
So this 8.33 that is now being required to be deposited in the pension fund, either from the employee or from your part, was never ever deposited in the PF fund. Or is it your case that this amount, I think there is a line somewhere in your writ petition, this amount we have already given you. You have taken that and then proceeded.
That is our
Show
case.
me that.
That is our case.
Show me that. Can we come back at 2?
My lord, they want it from the employee. They said you deposit it.
No, they have taken a stand
Because
somewhere.
No,
They
as
say-
paragraph 8 is also there. Now, however, the employee is already given an undertaking
no.
that I'm ready to contribute to that amount.
No, that is for the interest part.
Yes.
He did not, 82 something was the demand.
88 was the demand.
88 was the
24
demand.
was the basic amount to be deposited.
Just clarify this issue,
Yes, Lordship.
whether that amount was already enjoyed by him as a PF fund amount. Or because the scheme says your contribution under the PF scheme, section 6.
But to remit to that amount, I have to collect it from the pay that I
No,
was supposed
you will have to collect it if you have deposited in the PF account. Just check up that.
that I have to check.
Say 100 rupees,
Yes.
12 rupees I give, 12 rupees you as the employer gives, right?
Yes.
Now 24 rupees is deposited. If that be the situation, then that is the end of the matter. You have already made your deposit. It's for them to now go and
Can
find
we
it out.
Lordship have it on day after tomorrow so that I can have a statement of money that has been actually paid to him? Because that record I do not have. Let me have the exact
Okay,
statement
no
of money that has been
problem.
paid.
Thursday.
Otherwise, it will be like
That-
surmises
that's
and
better.
conjectures on my
That-
part.
Maybe this question that I'm asking is very irrelevant, but somehow that is troubling me.
I understand.
Just
Let me
give-
have
That's
the
right.
exact payment statement that has been given to him.
If you have deposited 12% from your contribution to the PF account, that is the end of the
I
matter.
understand.
Yes, obviously.
Because you have to make 8.33 from that 12% only. Somewhere I read, I don't know, I read that Supreme Court judgment also.
I'm not very sure. I have to check.
No,
Notice,
Supreme
notice.
Court judgment that
Otis.
Otis
Otis,
elevator.
Otis,
Elevator. Yeah, I have my holding.
if you go through that, also you get an idea.
Yes, Lord.
But I don't know why in that case abruptly things were stopped. If there was some more discussion, it would have been good for me, a person like me, who
For
is
me
not
also.
very acquainted with PF
For
matters.
me also.
On the prayer of Mr. A. Sharma, list this matter again on
Second.
Thursday, 2/5/2024. Mr. P.K. Roy, Learned Senior Counsel, assisted by Mr. S.K. Chakraborty, appearing for the Provident Fund Authorities.
Lordship.
Employees Provident Fund Authorities are present. It by slip query of not up 21. Kindly try to get that.
I'll get that, Lord.
The first two petitioners adjusted in.
My lord,
online.
yes, Lordship.
3-4, what happened? Yes, miss. No contact with the petition.
Lordship.
Lordship, this matter is come after long, year, Lordship, Lord.
Hmm,
I need to
hmm,
take fresh instruction, Lordship, though we have filed our affidavit, Lordship.
hmm. In your affidavit, you say you will give it to everyone.
Lordship,
But now the reply, they say that it has only been given to 1 and 2.
in affidavit, we have stated that, the creation of new Manipur Revenue Circle under.
3-4 were also included in that gradation list.
My lord, in the gradation of BTAD, Lordship,
Huh.
different.
No.
But the one
Were they included in the gradation list?
earlier
of-
gradation list, their names were included, Lordship.
But
In
only
Government
1 and 2 promoted there. 3 and 4 were not promoted.
Not promoted, Lordship.
So they went back to Bijli.
Yes, BTAD, my lord, gradation
BTAD.
list, they will get their seniority, Lordship. They will lose their seniority, Lordship.
How can they lose the seniority? They'll continue to get the seniority from the date they were appointed.
Now, my lord, they
Show
will be
me.
employee of the, my lord.
No, show me one thing, Mr. Ahmed. Let's say you were appointed on 1/1/2010,
Yes, Lordship.
right? When you went to BTAD, say in 2014,
Yes.
did they consider your seniority from 10 or from 14?
My lord, it is not clarified, my lord. It is in the district wise, my lord, seniority, my lord, gradation list, Lordship.
Fine, I got it.
If it is in
But
the-
your date of appointment cannot be changed. That will hold the
cannot
bill.
be changed, Lordship. Now,
Tell me that your date of
cannot be
appointment
said.
was.
In
This
the
is a
district
policy
wise, my lord,
decision.
seniority, Lordship.
This
Yes.
is a policy decision wherein government had shifted out some area to BTAD. That has taken its
That
final.
area has not been shifted, Lordship. That area still
Manipur.
now, that area
Manipur.
is.
What happened to that Manipur area?
Sorry,
Manipur
Lord.
area is still with
Boygaon
Boygaon.
district.
Have you instructions?
83 villages, Lordship.
On the prayer of Mr. MS R.B. Bora, Learned Standing Council BTC, list those matters again on 7/5.
Lordship, some more time.
Oh, 7/5 to Bondo.
Lordship, 2 weeks, Lordship,
13/5.
Lordship.
Lordship 17.
No, 13/5. 14
Right.
matter we are giving him.
Oblige, Lordship.
And Mr. Ahmed, you also have
Yes.
an instruction. If their
I-
seniority is protected, we may not
Well, I
like to
tried,
come in.
Lord,
Will
today
not
itself
come
I tried, Lordship, while
You
the
see,
council was there,
If
Lordship.
they have been given, they have been posted to BTAD area and their seniority is protected, we may not come. You get that instruction.
Oblige, Lordship.
Mr. Das, we'll take up your matter. We'll just finish up the list. We'll take up your matter.
In this case, my lord, the petitioner was terminated.
Has he come back? Has the petitioner come back?
No, I have no
So-
contact.
So,
Otherwise, I have to send again a letter, my lord.
no, that is up to you.
Otherwise, I'll do the case, my lord.
You do the case. The only thing here is that the allegations that are there in the affidavit in opposition, no. The only allegation against you is that you submitted a bill
Yes, my lord.
which was inflated. And you yourself admit that, no, I was not admitted to GMCH for any industrial accident, or I had taken a sumo or something. You had gone by because the two persons who have been sent along with you, they have submitted a bill for a bus travel. And you have submitted a bill for sumo travel. So the authorities felt that this man may not be very conducive.
The issue, my lord, is that that is not proportionate to my understanding, my lord. The punishment. is-
But what will you do? Your man is not there.
And moreover,
I can only bring him back to service. If I bring him back to service and he is not there, what is the use? Proportionality, fine, we'll go into. But the question is, if the man is not there,
then, my lord,
he went missing from when?
2000, last registered on 2019, my lord.
No, you said that.
I said it 2019, my lord.
When did he go missing?
I think more than 7 years has gone by already.
Then,
But if
no, this case will survive because if
then
man
even
is
if
not
it's
there
not there, the
also,
legal heirs will come in.
the legal hair has to come in.
Yes.
7 years if it is done.
But what I submit, my lord, otherwise I'll clarify from the wife, my lord, whether any trace of the husband.
Or you'll have to, after 7 years, a declaration has to be made
Yes,
that he
sir.
is no longer
Yeah.
alive. And then substitute the wife. Because if this case we interfere, you may get something.
That is true.
At least that proportionality thing. This penalty does not appeal, and the manner in which it was done does not appeal. When?
First week of June, my lord. Because I have to make a correspondence.
Mr. S. Counsel for the petitioner submits that he has no further information as to whether the petitioner has returned back home. Also, it is to be noted that the petitioner had gone missing and an FIR was lodged in the matter. Also, more than 7 years have passed since. No, but also accordingly, Mr. Count prays that he be granted some time so as to take up-to-date instruction with regard to the fact as to whether the petitioner has returned home. Also, accordingly, list this matter again on we'll put it on 20th, 21st. If you get it, you get it. Otherwise, you make a prayer.
Can it be, my lord, 20, my lord, 21st? I have-
205.
May I please your lordship? Lordship, I'm representing Mr. D. Bora for respondent number 4. We have filed an affidavit in connection with this petition on 2015, where we have stated that the deponent has stated that this affidavit is for the respondent number 4, which seeks to disclose its stand in the writ petition filed by.
What is the stand?
Uh,
That he is not your member.
No.
He is not your member. That is your stand.
No, actually, the thing is that, Lordship, the labels, the contractual labels were been given the remunerations from respondent number 3.
You have a copy of that affidavit?
Yeah.
Yes, Mr. Sharma.
If new affidavit file, I have not furnished with a copy, my lord.
No, we are not considering that. Forget it. That is by some Dhalaigaon unemployed youth. You have made them party.
Petitioner,
Who are they?
the petitioner, my lord, they are the members of the Indian Oil Corporation Limited.
So you had a tender for labor contract.
Township.
Now they have come in.
Yeah.
So they are continuing. Your grievance pertains to that period. Tell me, how can your only grievance is that it has to be referred to the industrial or the central industrial tribunal? Industrial a reference has to be made. Show me how can we pass that order?
No, our
Just show me
submission-
the law which says that we have to pass that order.
No,
Because the stand is very clear. The laborers are getting their dues in terms of the prescription made by the government.
Yes.
Contract labor, that act has been relaxed insofar as this unit is concerned. This industry is concerned. Now what is left? And today, after 10 years, what can we do?
Actually, our submission is simple. Actually, what happened, my lord, even in dispute, because the petitioner, they have alleged it. They are the contract labor engaged by the oil corporation through the contractor, respond number 4, my lord. But the payment has been made by the IPL, oil company through the contractor, my lord. So it is the contract labor, we also paying it in nature. Only since 1981, it has been going on. But they have been paying several replacement for their regulation, but they are not doing it. Now, so the
Regularization not possible.
now they have filed representations before the response number 2, the labor authority, for regulation of the labor authority has.
We will not accept that. It cannot be. Regularization cannot be a mode of recruitment.
The procedure is that, my lord, when the allegation is made before the complaint is made before the labor authority, they will have to hold consultation as per section 12 of the.
You tell me, why should we
Industrial
make
Dispute
that reference? You
But they
first
have-
satisfy this
they
court
have
that why that reference is to be.
They have made, they have called for a report from the oil corporation, my lord.
If they want to
But
do on their own,
They have
Mr.
denied-
Sharma.
They have denied that claim, my lord.
No, if they
of
want
the
to do on their own, we are not coming in. We are not coming in. If they want to do on their own, we are not. But regularization cannot be done. The law does not permit that. Anything to support your case, any case law?
No, that is when the procedure of the legal office can see the section 12 of the industrial district act, my lord.
Replace it.
Section 12. Section 12, my lord, consideration
You
of.
come to page 25, that is your prayer.
Page 25.
You tell me what is your right to claim for this regularization?
What is your right to claim?
You are appearing for respond number 3,
Yes, I have.
BRPL.
BRPL Bongaigaon, my lord. The 25.
And the affidavit that has been filed is clear. Mr. Sharma, you will have to satisfy me with some judgments. Otherwise, because you say abolish this contract labor system, but they have taken a license for that.
They have denied that they are contract labor. According to them, the petitioner has no connection with the oil corporation.
No, it has with the contractor.
Our contraction is then, it is their employee, but they have engaged them through the contractor, my lord.
That
Through
cannot
the
be.
contractor, and payment has been made by BRPL.
Now the respond number
for the
4.
year, my lord.
Now you are not there.
Sorry,
Now the
my-
respond number
my
4 is there.
contention, my lord, my contention, when we raise a dispute, then it was the duty of the laboratory to hold in consultation. with the
Now you
party.
show me one thing,
If
that there is a
consultation-
relationship of employee-employer relationship between you
Not,
and the,
no direct relation, my lord. That is indirect relation.
then,
That is the contract labor.
then, how can I?
When the.
If you have any grievance,
employee
go
has been-
against the contractor.
When the employee has been engaged by the contractor, it is contract labor, that is the indirect relation. Indirect relation.
They have a
So
license
have
for that.
raised it.
They have taken
They
a
have raised
license
that-
for that.
They should have whole consolation. If consolation failed, matter should.
Do you have
been
any
referred by
judgment?
government.
Do you have any judgment to
Because-
support this?
Appropriate government will see whether.
Mr. Sharma, do you have any judgment to support this stand? Any judgment to support this stand of yours?
Because my prayer is very simple, that is why I'm not.
That simple prayer is the most complicated thing in this, Mr. Sharma, the law. Simple things are very complicated. Do you have a judgment to support
The
this?
matter is going on from 1981, some of the employees died.
That's why I said, what is left here? Nothing
The
is.
matter is almost.
If you want to place some judgments, I can give you some
We
time.
are also pass an order and according to this matter. Because my submission is that the labor also.
We will not interfere.
They have heard the matter.
We will not do that.
They are the appropriate government.
Not do
Appropriate
that. We
government
will not do that at this distant point of time.
They have also stated that the appropriate government will see whether there is any dispute or not. So if there is any dispute.
The
then
appropriate government here is the central government.
Will have heard the
Yes,
matter
madam,
to
what
the
do you say?
tribunal.
Lordship,
The party matter the tribunal, my
they are
lord.
not
But they have
are
not done it.
employed by us. Lordship, we awarded contract, Lordship, kindly come to my affidavit.
Now, we have seen it. You make your submissions.
Annexer A, page number, Lordship. Page number 10, Lordship, work order. We contracted the respondent number 4 and they are employed by the respondent number 4. So Lordship, there is no requisition process, there is no advertisement. And they are not employed by us. And we have no role to in the engagement and terminating of any contract labor, Lordship. They are employed by the respondent number 4.
Mr. Sharma, there is an affidavit by respondent number 4.
Respondent number 4 have not filed any affidavit.
No, the copy was given here.
They have issued a certificate, an except 2, my lord.
And accept to your writ petition.
Yes, petitioners are working, working in the BFL engaged by them, my lord.
No,
And-
that is it. That is the affidavit. So they say you are not engaged by the Indian Oil. You are engaged directly by respondent number 4. So if you have any grievance, raise it against them.
The payment has been made by the respondent number 4 from the.
Mr. Sharma, there was a tender. There was a tender for contract labor. Respondent number 4 procured that tender. Then they appointed you. So the Indian Oil and you, there is no relationship. How can an industrial dispute be raised?
We could have been appointed by the BRPL, my lord, because the work is.
Was there an advertisement by the BRBL for these posts?
Work is in perennial in nature. In their contract basis, they had been engaged since 1981, my lord.
No, this is engagement is continuing because the same authority, same body is getting the work. That's all. What do you say? Any judgment is there? Any judgment is there? Show me.
But this section 12 of the Industrial Dispute Act is very clear, my lord.
Okay. Industrial dispute.
Section 12, my lord.
Hmm.
It is the duties of the conciliation officer when any industrial dispute exists or is apprehended. The conciliation officer may or where the dispute relates to a public utility service and a notice under section 22 has been given and shall hold conciliation proceeding in the prescribed manner. The conciliation officer shall, for the purpose of bringing about the settlement of the dispute, without delay, investigate the dispute and all matters affecting the.
Mr. Sharma, before you read 12, before you read the provisions of 12, can you kindly come to section 2K?
Yes, Lordship. Okay.
In the definitions, my lord. Section 2K.
2K.
Definitions of the industrial.
Definition, because when a industrial dispute exists,
Section 12, if the industrial dispute or contemplated or apprehended.
just can you come to 2K?
No, because the after. 2K is the definitions, my lord.
Hmm. So you will have to be a workman before that,
Section,
right?
section 2 is the definitions of the industrial dispute, my lord.
Hmm.
The section 2D,
Hmm.
2D, the consolidation officers.
Hmm.
means-
No. You come to K.
K.
Read that K.
Section 2K industrial dispute means a dispute or difference between the employee and the employee, or between the employee and the workman,
Hmm.
or between workmen and workmen, which is connected with the employment or non-employment or the terms of employment or with the consolidation. Especially terms of employment, because they have engaged for the contractual
No.
matter.
That will not come
Terms of
because
employment.
they have not.
No, that is actually matter industrial dispute. Whether it really be industrial dispute or not, it will be examined by the appropriate government, my lord.
Mr.
Only
Sharma,
labor-
I'm not very thorough with this line of
only
law.
labor authority.
No, you have practical experience in this line. I'm not very thorough.
Yes.
So kindly show me some judgments.
Then I'll have to take it that, my lord.
Okay,
Because
then
other-
we'll have it on Thursday.
Section 12.
We'll have it on Thursday. Thursday. Thursday, 2:25. You get your judgments on
Yeah,
that.
my last one thing I'll point out, my lord.
Yes, Mr. Sharma.
Clause 5 of the section 12, subsection 5 of section 12. If on a consideration of the report referred to the subsection 4 of the appropriate government is satisfied that there is a case for reference to the board or the tribunal or national tribunal, if they make such reference, my lord. Here the point is this, we have filed a complaint before the labor authority. So they will have to try to consolidate the matter with the labor, the all corporation, my lord. If the consolidation fail, they have to prepare a report when they have to
Place it
submit
before
to
the board.
appropriate government.
So show me.
And appropriate government will verify whether
Okay.
industrial dispute
Okay,
is
Mr.
there or not.
Sharma, we have accepted your plea. But just show me that in case of contract labor or labor engaged through a contractor, this provision would apply. Just show me a law on that.
Maybe after tomorrow, day after to.
Thursday. Let's this matter again on. You have any problem on Thursday?
No, Lordship.
2:5. You give a copy of that to Mr. Sharma also. Give a copy of this to Mr. Sharma.
We have to receive the copy of the.
No, they'll give you. It was recorded as any substance. When did you file it, madam?
My affidavit, I have filed on.
No, this respond number 47. You check up. Yes, sir. You tell him when you have filed it.
Please, your lordship, my senior is on lakes. Kindly pass over the matter for timely.
Today not possible. What is there? 1969
69, Lordship. He was given pension, Lordship, but as per
disability pension.
petitioner's
Husband.
Lordship.
Then
But
the
as per
petitioner retired in 2000, expired in
1969.
2006.
2006.
So between 69 after invalidation and 2006 he married the petitioner.
Lordship.
Right?
But Lordship,
Now this proceedings is in 2016.
16.
Why should we entertain all these proceedings? Ask your senior. List this matter again on 9/5. Ask Mr. Padgiri, review, tell Mr. Padgiri review of this book. It cannot be. And you keep ready those provisions.
That's it.
Invalid pension and disability pension. Two different concepts. Just keep that ready.
Yes, Lordship.
18 to 20.
My lord, may I please, Lord?
Good client, 3 cases on the same point.
My lord, only my lord, I am my lord, I can my lord pay many things, my lord.
You don't pray anything, you just tell me.
Yes, my lord.
You claim from 2009.
Yes, my lord.
Above you, there is a man called Padmodhar Das,
Yes, my lord.
right?
Yes.
Tell me if I'm wrong.
Yes, my lord.
Padmodhar Das promoted in 2011, right? Now you cannot go above Padmodhar Das, can you? So your promotion will be on a date after Padmodhar Das promotion. Now you are subjected to a departmental proceeding. That penalty continued till 2016. In 2017, you were promoted. Now tell me what is there.
My lord, only thing is that, my lord, as per this order, my lord, I am deprived 2009. Lordship kindly will look page.
The order of this court.
Yes, my lord.
You come to that. Come to that order.
2016, my lord.
I know. You come to that page
page 26, my lord.
26. 647 2012.
Yes, my lord. Yeah.
You come to the
Paragraph, my lord.
last
Second
paragraph.
paragraph, my lord. Second
No,
paragraph.
you come to the last paragraph.
Yes, my lord. Last paragraph is
In
provided.
view of the above.
Yes, my lord. When, my lord, I am promoted, my promotion.
Wait, Mr. Barmia. In view of the above, respondents are directed to consider the promotion to the post of so and so in accordance with law within a period of 3 months from the date of receipt of a certified copy of the order. Stop. Respondents may also consider.
Yes, my lord.
So, if they can't consider your case because of the incident facts, no violation.
No, my lord. This departmental proceeding, my lord, subsequently, I am already deprived 2009, my lord.
You cannot because Padmodhar Das got it on 2011. He's seniority.
No, lord. No, lord. So, kindly, my lord, I may be allowed to.
Yes, tell me. That much.
My lord, in the, my lord, in this judgment, my lord, it is clarified, my lord, that, my lord, how I am deprived in the 2009, my lord.
This court did not issue a mandamus for your promotion from 2009. It said they may. The court issued a mandamus for your promotion, right?
No, lord. It was, my lord, held that, my lord, I am deprived 2009, my lord.
Forget it.
Lordship kindly have a look, page 28, my lord.
We are not concerned. Once there is a department proceeding and a
They have
penalty.
promoted, my lord. Already I am promoted, my lord, but only, my lord, as per this order.
2017 you are promoted.
17, my lord.
Well done.
Because, my lord, in the middle, my lord, if departmental proceeding is, my lord, there, my lord, at all, but I am already deprived in the 2009, my lord. So, as per order of this judgment, my lord, I am.
How can you go beyond covering that?
This judgment, my lord, provided.
No,
Lord,
it just gave an option
No.
subject to application.
no, lord,
Yes, Mr.
last
Wait,
part, my lord.
what is the issue?
Yes, sir. Last part, my lord.
Hmm.
It is made clear that the petitioner shall not be entitled to salary of higher grade for the state period from 1/1/2009
No,
till his actual date
we
of
are
promotion.
we are not satisfied.
However, my lord, petitioner will entitled to all other consequential benefit as such promotion, my lord. So, my
That
lord,
is if you are promoted from 2009. You cannot be
no,
promoted from
they are, my lord,
2009.
what they are saying that, my lord, I am not promoted due to, my lord, departmental proceeding,
No.
etc., etc.
No, they have other
Just
points
get it
also.
sit
You
over.
don't meet the cutoff.
No, the last case, my lord, I have challenged, my lord.
Two resolutions
Yes, my lord.
of
Yes, my lord. There are cases that, my lord, due to, my lord, as per this judgment, my lord, I was not promoted because of, my lord, there is a departmental proceeding, my lord. And when, my lord, this effect of the departmental proceeding is over,
they
then
were promoted. They promoted you.
they have promoted, my lord. So why they have not, my lord, given me the benefit from 2000?
You show me that in spite of that penalty, your case can be considered from 2009. I am passing the order now with all consequential benefits.
No, I understand.
Once that penalty is there, how can they promote you? How can you be considered?
But, my lord, they illegally, my lord, direct me, my lord, under penalty, my lord, because I am deprived already 2009, my lord. So,
First time you came before this court is 2018.
18, my lord, 18,
19,
19, 21.
21. Okay, we will give you one more opportunity to go to pre-appeals.
No, my lord, another date may I will satisfy your lord.
No dates.
Because, my lord, because it is held, my lord.
Anything more, Mr. Gogoi?
No, my lord. In fact, my lord, in 2013, it was considered on merit and it was kept in shield cover.
Shield cover.
Yes, it was, and that has not been put to challenge, but that order has not been put to challenge.
So I'm challenged, my lord, everything in the last item case, my lord. Lordship, another, my lord, part or another date may be, my lord, I will clarify all these things.
Don't try to get us. 8, 9. Board is 8 তারিখে 8 তারিখে আছে। Hard in part. Heard Mr. A.M. Barvia and Mr. B. Gogoila. Frank Barvia on a standing counsel for the petitioner. Also Mr. B. Gogoila, standing counsel, finance department. Heard in part list again on Punila Devi.
Even, my lord, even today, my lord, my case is of, my lord, 2009, my lord.
Full lottery. Lottery not again. Take it. What technology? 8, 8, 5.
Item 19, I'm for
Apply.
You are appearing. Or
Item 19,
whoever is just put in us. With the respondents. Huh?
Diploma.
Okay.
May I please, Your Lordship?
Hmm.
This is the jurisdiction of BTAT.
Show me how you can be. Yes, what is your instruction?
Lordship, only yesterday they sent me a copy and I have sent it, Lordship, a week's time, Lordship, to get that instruction. Whether the people of that.
We don't want, we only want, how can you incorporate this condition?
Yesterday
Whether this is
only,
en
Lordship.
bloc preference, then don't hold the selection. Then don't hold the selection. That's all.
Only the preference will come if everything is.
Everything is equal. That's all. You can't have a special en bloc.
Lordship,
When?
a few days time, Lordship.
When you tell me, give me a date.
Next Monday, Monday or Tuesday, Monday, Lordship, Tuesday.
On the prayer of Mr. B. Chaudhary, list this matter again on 6/5/2020.
Obliged, Lordship.
Obliged, my lord.
Yes. Yes, Mr. Soikia. How can we help you here?
My lord, though the petitioner was qualified, my lord, on the date of his initial appointment as per the
Initial appointment in the
88,
in the private in the venture school.
my lord.
Will not.
That university system.
Will not. You were appointed when? 88.
88, August 88.
6/8/1988, my lord.
Yes. What happened to your instructions? 24/7/98. If that be so, he's entitled. When was this college was provincialized?
My lord, 2014, my lord.
Under the 2011 Act.
11 Act.
You're not entitled. Only condition now is the government in similar situated cases has given the UGC scheme.
Mr. K. Gogoi is coming.
Where is it?
He's coming. Large enough.
If that be so, you will get it with interest.
My lord, I have submitted one notification of 1987, my lord, a copy I provided in last occasion. Where it is said that the minimum
No,
qualification.
we'll not go into all this. Today we have to rise at 3:15. That's
3:15, yes.
the-
Some other day, my lord.
We have taken time on several occasions.
List this matter again on 8/5/2024. On that day, we will finish it.
Well,
Obliged, my lord.
Yes.
My lord, may I pray for the accommodation, Lordship? Senior counsel TJ Mondo is on legs. Lordship.
Mr. Monto will be on legs. It is expected. You should take wholly feel till then. That whether that period when there is no student will be construed to have be the experience, teaching experience. That's the issue.
Yes, that's.
On the prayer of the parties, list this matter again on 21/5/2024.
On the last occasion, my lord, records were directly produced, my lord. That make it.
If the records are there, you keep it. Whoever
Yes,
has
sir.
it, keep it, because first will not.
The application
Futile.
forms, my lord, only the application forms.
Forms of yours and the,
Two
just to
petitioners and the
understand
reciprocity.
what he has given for the qualification
Yes,
and your allegation that 10 research papers are required.
Yes,
He has one, others are co-authors. That's much.
yes.
It's-
On 21st, my lord.
Preparing for respondent number 8.
Just write your names, whoever is appeared, and give it.
Deeply obliged.
Mr. Doctor, sorry.
It'll take some time, my lord.
We'll have to rise. We'll fix it. List this matters again on 21/5/2024. Can't help it.
Lottery is 61, madam?
21.
21, madam.
21.
Well.
Date will be given, my lord.
Hmm?
A date will be given.
Why? We were supposed to dispose of this matter today. There is enough time for this case, don't worry. Yes. How can we relax? Tell me. Where is my power to relax a recruitment rule?
Yeah, my lord, the
That is your case. You don't have graduation. You're not covered. So relax. Show me the law.
in earlier round of litigation, when my lord,
Forget the earlier round of litigation. We are now in this round of. That did
This-
not take you anywhere.
this honorable court, my lord, division bench, my lord, in the WBC number 997/2016 held that there should be some avenue for their promotion.
Whenever they give it, there is an avenue
But-
with a bar graduation, and that is applicable
And that is-
across the state.
That is for direct recruitment, my lord, in the,
Even for promotion in other departments, it is.
it is there
Graduation.
as per 2015 rule.
So show me how we can come in.
Any other date?
Tomorrow. It'll by slip code. On the prayer of Mr. B. Pukhastal, is this matter again tomorrow. No? By slip code. What I want to like? What I want to by slip.
Lottery on the last occasion, lottery directed us to.
No, they have submitted a written argument in this matter.
But I also prepared.
Give it to me.
And
Then we'll fix a date. Mr.
Yes.
AG would be appearing, I suppose.
yes.
On a date convenient, we will hear the matter. When, Mr. Das? You see, when?
Day after tomorrow.
Tomorrow, day after, don't. Anyway, they are suffering. I can't. I'm restraining myself. Can't help it.
May have a next 22 is a Wednesday.
21 law. Tuesday law.
14th of May. May Tuesday at all, 14th.
14 May. Let's this matter again
14.
on 14/5/2020. On the prayer of the parties, let's this matter again on 20/5/2020. 14/5/2020.
Obliged.
Obliged.
In this case, SSA is supposed to take it second. Hey, 29. Last time SSA.
Yes, the allegation is that if the school did not have DIAS data till 2009. What is your stand on that?
Kindly come to the page, annexure to page.
Tell me your ground.
Page 39, Lordship. That is the actual fact, Lordship.
What this one, idea?
Then lordship, page 50 is the dice code lordship, page 50, and exercise 6 lordship.
What is the name of your school?
Pochim Hekaipara LP school lordship. Page 50 lordship.
Affidavit from Sasha. Our affidavit, second file affidavit from Sasha.
Yes, Mr.
Lordship, so far as my instruction is concerned, this school has set up for the year 2008-9 as SSK.
As EGS.
SSK.
That's your school, EGS or something.
Earlier it was as EGS.
EGS.
For the last 2 years, that is 8-9 and yes, 8-9.
8-9, huh?
It is as SSK.
SSA means?
It's Sangyogi Shiksha Kendra.
Now, whether that would be also counted for this elementary education provincialization?
Subject to fulfillment of other criteria. But in the rule, there is nothing. That is the confusion.
And whether they can be construed to be a venture educational institution.
But there are instances where EGCs are upgraded to LPS.
Fine.
But SSKs were never upgraded to LPS.
Even if that is upgraded to LPS, will they be a venture educational institution or an institution under the SSA?
Well, no such instances are there, Lord. So that is the issue.
We'll examine. But on the prayer of the parties, list this matter again on.
But I mean, I believe what is it.
15/5/2020. Mr.
15-5.
Mac, if you can get some material on this, just EGS, SSA, whether they can be construed to be an venture education institution. You also work on that. If it can be, then we will reckon you that dice data and then ask them to consider.
It was converted by the SSA lordship, not
to an
by the
LP
age of
school.
the- Yes, lordship.
You satisfy me on the next thing. Forget everything. After 42 years, why should we allow?
My lord, 43 years, whether the period is 3 years.
Forget 3 years. After 43 years,
Understand.
why should we? You were born with that date, continue with that. At this fag end of the life, why all these things?
The two things, my lord, if I may say this way. put it this
1
way.
year.
No, I'm not on that.
You're a serving employee somewhere?
Yes.
Okay.
Look,
You're not employed.
regardless of the fact, I'm thinking aloud. I understand what lordship has fallen. Regardless of the fact that my retirement is due, a change so far as the admit card is concerned can be of a person in service or not in service.
Okay, you tell me. We will have the change made in the admit card, but you will not claim a day more than what is recorded in your service.
This is not even my prayer in the petition.
That need
No,
not
what-
be. That is a consequence that will follow.
No, what
We know Mr. Bonik. Bonik will never make prayers, unnecessary prayers.
what I'm considering to the effect that
You make an undertaking that you will not stay in your service for 1 day, considering 64, I am passing the order.
is not even
I'm
that-
passing the
that
order.
is not in the realm of the petition. What I'm willing to praise, there is judgment against me. Supreme Court judgment against me. I mean, absolutely fair.
You're always fair.
I am. It says that this Seba matter went to the Supreme Court. In other case, it says that the condition of 3 years is a reasonable one. If you have not done that, you have missed the bus. So far, so good. The matter traveled way down. And recently a Supreme Court judgment has come in which that matter was also discussed. The quorum is larger. It's interesting, a fine distinction has been drawn. There, many persons were there who had wanted.
What is that subsequent case? Earlier one? Okay, subsequent case?
The Seba case was the earlier one. The subsequent case is a 3-judge bench.
No, which is the one?
The name,
Citation?
Digya Yadav,
Yeah.
No,
CBSE.
CBSE.
That is not a recent case. That is an old case.
The subsequent case, I said.
Show me. Therein, this issue of delay was taken into account.
What I am on, I will address your lordship on that. For a moment, if lordship dares.
matter heard, list this matter, prayed for by the parties, list this matter again on 6/5/2024 for further hearing.
The core issue was, as I.
Jigya Yadav,
No, Jika Yadav touches upon the part in the correction and change.
next day we pass the order, don't worry.
Absolutely.
Jigya Yadav is with regard to change of
Change of
names.
No, Jika Yadav with correction and change, the distinction is brought in.
No,
If I rely on the records, the school records, to effect the thing, it's a correction.
We would have permitted, but the lapses and delay of 42 years, we are not entertaining.
That's one way,
That is the only
Lordship
way.
has fixed the date.
We are having it on 6th.
I've pleaded the reason for delay.
Huh?
I've pleaded. Anyways, I leave it to your lordship.
Your pleading is your father died, then he opened his box, you got the medical
I
certificate.
did not leave it there. I went and applied and then I got it corrected. Anyway,
We'll not.
anyways, obliged.
So you want a longer date.
No, shorter one.
This court,
The shorter one.
this court
Before
has
you-
expressed.
I'll address your lordship on that.
This court has expressed. If you want, you take a longer date.
But I'll try to persuade my, not the other way around. That's fair.
Doesn't go in.
Anyway,
Yes.
May it please, Lord.
Yes, Dukiram Day. Yes, what do you want? here?
Rukiram, my lord.
Hmm.
The State Scrutiny
You
Committee.
want to
my
make him Kukiram? Okay. Now come to page 31.
lord, my lord.
Is the position there okay?
31,
31.
my lord.
Is the particulars given there okay?
Okay, my lord. Rukiram,
Ratnakar expired on 26/8/2019.
19,
Subhash Biswas English.
my lord.
Naren Chandra Das Maths. Someruddin Ahmed Hindi. Right?
My lord.
Now you are MIL. Your language.
My lord.
There is already a language teacher.
My lord, subsequently, my lord.
There is already a language teacher.
Madam.
Social studies, somebody will come in.
My lord,
Yes, madam, you are appearing for.
after that,
Number 6, Lord,
Who is respondent number 6?
the headmaster.
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 You have nothing against the headmaster.
my lord, after that,
Headmaster is senior to you or junior to you?
my lord, junior, my lord.
Junior.
I am senior.
Then yes.
I am the senior, my lord.
You have filed an affidavit in the matter, ma'am.
Yes, Lordship.
What is your stand?
No affidavit has been filed, my lord.
You have not filed an affidavit.
Allow me 2 weeks time for filing affidavit, Lord.
On the prayer of the learned council for the respondent number 6, list this matters again after 4 weeks on a date to be fixed by the registry. Also, in the meantime, the parties, respondents are at liberty to bring on record their respective stands by way of filing affidavit.
Obliged.
May I please? This is my lord covered by the lordship order.
Mr. Bora,
My lord, dear, my lord.
100 kilometers,
One day,
beard,
yes,
counter allegation, 34 kilometers,
my lord,
34 kilometers. In your case,
my,
34,
my lord,
30.
my,
34 kilometers. So both not next door, little bit distance. How did you go?
my training was, BA training in my school was given.
We will not
Number
consider
one.
that.
Secondly,
We will not consider
today
that.
I am not on that.
We will
Different
not
issue is
consider
there.
that. Mr. Bora, you
No,
clarify.
I am different issues there. Now, the pending departmental proceeding on, he cannot entitle the any promotion.
You show me the shukos.
Yes, yes.
Very sure.
Yes, under rule 9. He suppressed because of that. I filed affidavit stating that the departmental proceeding one, he did not say anything. Hello, your lordship, see there.
We have given
Without
the reply, my
completing,
lord. That's
rightly or wrongly, there is a departmental proceeding. Without completing the department, he cannot entitle any promotion, my lord. He
We are
cannot,
not-
honorable apex court settle
You
position of
do
law.
one thing.
Settle position of
Do one
law,
thing.
my lord. He
On
suppressed
the
the
ground
material.
of delay and latches, bring this, challenge this.
Yes, my lord, he can challenge it.
Who is holding the post now?
Inspector of schools.
Okay, they're very good. On the prayer of the parties, list this matter again after 2 weeks on a date to be fixed by the registry. Go ahead.
Much obliged.
And if this,
I am going,
if this challenge comes to me,
my lord.
I will state along with reasons.
I also going to challenge his BF, my lord, by writ petition.
At the same time, protect your beard also.
Yes, my lord, I have no problem, my lord. Lots of lines. I am sorry for that.
That much banter we can have.
My lord, my lord.
34 to 30, 37.
37.
We'll have it on some other day.
But lots will fix on 8, my lord.
8,
Because it is
he is also playing, my lord.
Anything?
is dependent by the AG, my lord.
8, we cannot. 8, any other date?
Then let it be on 14th, my lord.
14. 14 can I parigone? 14 parigone? Thirteen.
13.
13-5.
13th, my
On the prayer of the parties, is this matter again on 13-5? Yes. Okay. Sir, I'm sorry. Today,
Anyway,
again,
my lord, my fear is, my lord, we are eager to conclude this case because we are suffering of the pandemic.
I can't. Today,
Well,
I'll have to, because if I touch this, it will not be finished.
Once content will be given, my lord, not on 6, my lord, because I am out of session on 6, my lord.
Next week, impossible. 6 that week is impossible.
On 8, my lord,
Many
9.
matters.
9, my lord.
Today, I did not know.
Is it possible to on 2nd, my lord?
This week, next week, I'm sorry.
The lordship give a convenient difference.
21 or board is any question? Huh?
On 21, my lord, Tuesday.
21, Tuesday. Can't help it, Mr.
Hello, because our
That's already.
registration and everything
But
is pending.
your that other case will have a bearing here. If that gets forward, this will not be required only. The other day you moved the case.
yes.
What happened to that? Has it been listed before the division bench?
That is listed on 2nd, my lord.
Second, on the prayer of the parties, list
That
this
is a
matter
fix-up?
again on
Fix-up?
21-5.
It is fixed.
40. Yes, Mr. Das.
Links in court number 2.
Oh, we fixed it for 2. Unfortunately, we could not.
We have lordship.
We have got it. Any instructions, Mr.?
Lordship,
We'll have to contest it. Contest it.
and we have also obtained the CDs and others.
That when you have free time, go through, make clips, give it to us if required.
I'll go through and if anything is required, I'll show it to my friend.
You tell me if you find something, tell me that is enough for me.
Lots.
You need not take the trouble
No,
of
no.
making copy of that. That much we
Otherwise,
know, Mr.
otherwise,
Kaya.
we are ready with the records and our submission. Today probably it is not possible. Lordship may fix on some other day.
Lordship can start lordship. In the meantime, he will come lordship.
Sorry, why don't I-
On the prayer of the parties, list this matter again on 9/5/2024 at 2 p.m.
Much of it.
Deeply obliged.
In this case, today I missed the file, my lord. It has come in the supplemental list and I.
Today this matter is fixed for delivery of order.
Unfortunately, it was shown as admissions. Yes.
I have missed the file today, my lord.
What was the issue?
Issue with regard to my lord,
Regarding the,
already lordship, the
Yes,
connected cases are lordship.
yes.
Challenge it with regard to his B.Ed degree, my lord, that was, my submission was that, my lord, it was
No.
obtained during the period when it was not under the
No,
cover
no.
of the NCT.
That report. No. It's Mr. Okay, so you know better. You have done hundreds of cases like this. Huh?
in fact, let's see that
95,
in disposable.
96 the application was made. 97.
Affiliation granted by the university after the enforcement of the NCT Act, my lord. That is not permissible following the
How did
provisions of
the
Rule 16, Rule 16 and Rule 14.
How did the university allow them to sit in the examinations if the college was not
Let the
affiliated?
university explain by filing the affidavit, my lord.
On it. What has happened at that point of time, we have condoned it. Yes, Mr. Fugon. Mr. Fugon has gone. He's the main man. He's gone that side.
My lord, that degree is still valid, my lord.
Then that is the statement we want. Disposed of. And you search similar matter orders, you will get where you argued. Here, other side. Right?
Both the sides orders are there.
There. That is the beauty of Mr. Prakash.
Both the side orders are there, my lord.
Okay.
Oblige.
Oblige.
No, dispose.
Lordship, can you see the Lordship order 17?
Mr. Deka,
17
Mr. Purkaiso,
17
kindly apply for your certified copies. The order may get delayed. I can't help it.
17
I'm being a very shortage.
My lord,
Yes, sir.
order that was 17 to 24. Lordship order.
Huh.
Now can be seen, my lord.
17 to 24. Okay. We got it. Yes, what happened? What is your response from the government?
My lord, here sometime is required, my lord, file pertains to the matter, my lord, is in the hand of the R. Mojumdar, my lord. So, my lord, next week, my lord.
So he has kept it in lock and key.
No, my lord.
Then he is flying around these days. He will not get him at least before a week or so. You know the news. His daughter's success.
Yes.
In that tournament. Where did you get him? If he comes, everybody will ask for party. So he will not come. At least for 10 days, he will not come. When that thing goes down, he'll be here. Have we thrown a treat to you all? No. No treat. Mr. Chisti, you've been given a party by him? No. That's it. Mr. Soikia, we'll ask them because we asked them to get that response from the government. Let's see if that happens. Otherwise, if we go strictly with that order passed by the director, maybe an argument can be raised that there is no willful and deliberate violation.
Only Lordship.
Mr. U. Sharma.
What is the?
That's it. Mr. U. Sharma Lanat, counsel appearing for the respondent, submits that he be given 2 weeks further time to receive the information as sought for by this court, while the order dated 17/2/2024. List this matter after 2 weeks on a date to be fixed.
That may kindly be given because this lady is suffering a lot.
It will come. If it doesn't come, make a mention. Sorry. It's a question of maintainability. Yes. What is the decision you have? Decision. At least give me the decision. I can keep myself abreast on that. Mr. Mojumdar is also here. Somehow we are not in a position to give this case a final hearing.
Lordship, first I would like to rely upon 2 decisions of the Supreme Court. Where the Supreme
Mr. Das, we have heard your matter. We have reserved the judgment.
Lordship.
We have heard your matter. Finished. You have got no case. They have produced the records. When have you fixed it? It issue? It issue now? 40? 9-5. Can't help it.
9.
Today we are rising.
I understand, my lord.
You also got to prepare your speech, so we freed you.
The only thing is that there is some anxiety.
Oh, there is interim order passed earlier to continue. Interim order is
interim order.
continue.
And will it be possible to Friday, my lord, or difficult, my lord?
Friday.
This Friday.
This Friday.
Difficult.
This
Fine.
court will have a difficulty.
Fine, my lord. No problem. Deep.
In these 2 decisions, Lordship, Honorable Supreme Court has held even the private institutions imparting education.
Private institution?
Imparting education is a
This
public
would be
function.
this would be in the sense of when they are Deemed university. Deemed university is under an
because
act.
there are two decisions. One is the society which is running school, and another one is university lordship. So we have two examples from Honorable Supreme Court,
The St. Mary's School is
where it says that the
St. Mary's School,
yes,
Education Society.
lordship. It says that imparting education is a public function. So once it's a public function, so writ and public law remedies available to the petitioner only to the extent of public function, but not in respect of other contractual issues. I'll come to the relevant paragraphs, lordship. Then after that, there'll be decisions where, so far my case is concerned, lordship. Number one is the union
Mr.
of.
Mazumdar, it may not be possible today.
Yes, yes.
We'll have to go.
But in this case, I'm just speaking out. In a given case, my lord, even a writ petition against a private institution may be maintainable.
Against a private person may be maintainable.
Question is, my lord, the impugned action should be
In discharge of that public.
yes. So here, what has happened, my lord, the prayer they have made is they have prayed for a direction of issuance of mandamus against the education department to cause an inquiry. Now here, as your lordship is aware, my lord, for asking for a mandamus, they must show.
You have not
that there's
asked
a-
for any relief against that.
That's what I'm
society.
saying, my lord. That's what I'm saying.
That we have noticed, Mr. Thank
His
you for.
grievance is against that organization. He could have prayed and he could have made a submission that against that organization, since they are discharging public duty
Function.
like imparting education in technical discipline. And they are discharging public duties, so it will lie, so issue this action to them. They have asked for a relief of issuing mandamus to the education department to cause an inquiry. Education department doesn't have any legal duty to cause an inquiry to each and every unauthorized private organizations
They did not.
to oversee their functioning. I think they
It would be
amend
like-
I have got
It
one
would be
sympathy.
like making a newspaper or a magazine
Yes.
responsible for all the advertisements
Yes,
that
but
are
that's-
published in
That
that.
is,
That
no.
cannot be.
My lord, one
Ah,
thing,
if the newspaper does something, proceed.
my lord,
Education department has
I
come
have
up-
got my sympathy for the students who have
We have,
suffered.
but we cannot.
But my suggestion will be subject to what this honorable court says. They may amend the petition, make their prayers correct.
In connoissance with you, or they can withdraw it with liberty and
Yes,
then
yes,
file back. There is
yes.
no problem. We'll
I'm
permit
not
you.
saying that they don't have any grievance. They have a grievance and they're.
Mr. Todi, he is right. It's not because of the institution, but because of the nature of the relief.
Yeah.
Even your this, St. Mary's will not come into your aid. St. Mary's says is with regard to that intra-institution disputes, employer.
That is one part of the.
Then this, and it says that if it is in discharge of its public functions, a writ may be maintainable.
Exactly, man.
No dispute on that.
And the last pair, as your lordship has indicated on the last occasion, the last pair is the OC has been made a party saying that we have lodged an affair. Then as your lordship has indicated.
Criminal case,
Here
set
is
that at
there,
motion.
156.3 is there.
So my main.
Let him
point-
amend the petition and.
Number one is Union of India, where Ministry of Human Resource has issued notification where they have debarred any off-campus institutions being run all over India. So it is the responsibility of Union of India.
Okay.
Then
We will
coming-
test that. We'll test that.
Okay.
Now, your grievance is that you went there to study
Gotcha.
and they were duty bound to teach you. Right? Is your prayer that that institution is not permitting me to come there to study? I should be permitted to continue my course. That is not your case. That case, your case is your writ petition if we allow. If that institution is not closed down, it will be closed down now. What benefit would it accrue to you?
So my was that inquiry in respect of that institution, when we have raised complaint before the state government education department.
That we are
Even
not
the
into.
state of Assam has come up with an office memorandum that is.
Okay,
dated
what is that
2012.
enquiry report for, required for, according to you?
What's it?
Why is that enquiry required according to you? What for?
How it was permitted to run lordship.
Right.
And when we.
Okay,
approach the
we tell you,
institution,
we tell you, that was a most bogus thing done. Then
We
No,
approach
state
the
never permitted
institution,
to
they have-
run.
when we approach the institution, they have made us to believe that it is functioning with a proper affiliation, which was not true.
That is what I'm saying. For that, they have committed a fraud on you. Fraud is the criminal case, not a writ.
For criminal case and.
If you want to argue, we can argue for days together, but what is the use? What do you say? You want to?
In that case, I had one persuasive precedent, Lordship, in respect of High Court of Bombay, where similar matter, a student who was defrauded by the institution which was running without affiliation. In a writ petition, the Honorable Court has entertained and has also issued direction to the state and central government to cause an inquiry and take penal action against those institutions, as well as granting compensation to the petitioner, Lordship. That is persuasive precedent because on that fact, there's
Unfortunately,
no
maybe
other.
we are not broad enough to think in that manner. When, Mr.
Next Thursday, Lordship.
Mr. Mazumdar?
Next Tuesday?
Tuesday will not be here, elections.
Or Tuesday election, 7th.
Nobody.
Thursday is good enough.
Eight, Wednesday?
No issue. But it would be in the faggot.
Then 9th.
Ninth also same problem.
9th I will not be here.
You are, when are you here? That you will not be here. We can have it on 14th, if not 14th, 5. On the prayer of the parties, list the matter again on 14th, 5. A Todi, D Mojumdar. Mr. Mojumdar, you are assisted by?
Yes, not.
Additional Advocate General Assam, assisted by Ms. S. Nath, appearing for the state respondents, and Mr. A. Somoa, Learned Standing Council UGC. Madam, you are appearing for?
Mr. M. Hollis.
For? CBA? CBI is also coming.
There was also included as a party in this case.
Oh.
Because we had laws in FIR before CBI also does.
Okay. How was it?
Much of those.
Have they got the details, Mr. Goswami? We'll have it tomorrow.
Tomorrow.
We'll have it tomorrow. Ali, hearing
that will
remains inconclusive. We'll have it tomorrow. List again tomorrow by slip coding.
Day after tomorrow, can it be? Tomorrow, so many cases have been fixed.
We are here. Tomorrow, small point.
Only 1 point, my lord.
1 point.
Vote number 1, all these cases are.
That you have. I am free. I'll have it. You have done your submission. It's only his submission.
I have to submit some of the.
Judgments, your junior will submit it. Don't worry.
Only
And Mr.
record has to be.
Chetri, if we come to a situation where we want your assistance, we will wait for you. That much assurance I can. What happened to your IA?
No, it seems that the record has not come in the record is not available here.
Tomorrow.